You ain't gotta say a word, just walk that, let's get burned. Then we'll roll up 100 fucking blunts. All up in my mouth, now all up in yo. This nigga got pounds of it, all up in his trunk. Now we both look Asian, he waving and I'm drunk. I got dank shit in my cup, you know what I'ma do to you. I could give reviews to you, slow, we X, and we sipping on that juice. That's just what she choose to do.
Where do you end? Where do I begin? Start over again.
see. I know you are there, smiling back at me, dancing in moonlight. I know you are free, 'cause I can see your star shining down on me.
at 5 in the morning. I wake up to fight for my earnings. Fear in my mind is a warning. Pray to the one you're relying. I've been wandering all day. I tried to be fine, but I can't be. The noise in my mind wouldn't leave me. I tried to get by, but I'm burning. I'm behind, my mind it runs. All these thoughts have troubled me. Fighting to give up my pain. Fighting to be on my lane. My mind running to the other side. When it's time to leave my life, then it tries to take me out. Tell you what I need. Right, yeah, I really need time now. I need to free mind now. I really need mine now. I need to free my mind now. I really need time now. I need to free mind now. I really need mine now. Yeah. This is the peace that you cannot buy. Send me a love that you cannot mix. One is the joy that you cannot waste, and the other one price that you cannot fix. This is the peace that you cannot buy. Finding a way where you cannot see. Man with this system, he cannot breathe. I need to find relief. But behind my mind, it runs. All these thoughts have trouble me. Fighting to give up my pain. Fighting to be on my lane. My mind running to the other side. When it's time to leave my life, then it tries to take me out. Tell you what I need. I really need my love. I need to free my mind. I really need time now. I need to free my mind now. I really need time now. I need to free my mind now. I really need time now. Oh, yeah. Just let me free, freer than the open mind, farther than the eyes can handle, freer than the ocean now. Yeah, yeah. Just set me free. Now I need to find relief. Set me to the open sky. Now I need to free my mind. Yeah.
Drop top Porsche, rollie on my wrist, diamonds up and down my chain. Cardi B straight stunning, can't tell me that the bossed up and not changed again. It's my big bronze boogie, got all them girls shook. My big fat ass got all them boys cooked. Some dollar bills, now we popping rubber bands. Bruno sang to me while I do my money dance like, yeah. Flexing on the gram like, yeah. Hit the little John, okay. Oh yeah, we keeping it finesse again. Ooh, don't we look good together?
Good morning. Good morning. Happy Friday, everybody. Come on in. Come on in. Come on in, y'all. Good morning, Miss Lynn. Thank you so much, Miss Lynn. Hey, Malika. Good morning. Happy Friday, everybody. You two are the only ones in the chat so far. Okay, then. All right, y'all. We're going to get started. Look, I got a long day ahead of me. Okay. I'm built for it. I love it. But, hey. Make sure as y'all come in, y'all double tap the screen to like the live stream. I appreciate it. Feel free to support the channel. Links are pinned at the bottom. We're going to get started. I got the... Y'all know we're going to get into the exhibits today on this live. Put a one in the chat if y'all can hear me. Actually, I can check my own device. Let me see. Oh. Let's see how y'all look on this device. Because I'm not even sure. Can I hear myself? If I can hear myself. Let me turn it up. Can y'all hear me? Can I hear myself? Oh, okay. I hear myself. So y'all hear me. All right. Oh, okay. I hear myself. I know we're talking about Carmelo. Malika. I got a live schedule right after this to talk about that. It's scheduled right after this live. All right, y'all, let's get into it, okay? No, you good. You good. Hey, keep it cute. Hey, girl. Good morning. Happy Friday, everybody. Y'all come on in. All right, so I'm going to go back a little bit, just a little bit. Hello, Mama B, a blessing to me. Oh, wow, I like that name. Good morning, K. Kelly. He won't get a new trial. He may not even get an appeal. He's guilty. Okay. Your opinion is welcome. As long as you're respectful. No problem. You good, Malika. You a good girl. But I saw that. And his parents spoke on Good Morning America too this morning. I got that too as well. So we're gonna get into it right after this one. I got it scheduled for 12. We may get through this before 12. So whenever we get through with this one, we'll just go right into that one. But it's already scheduled. So if you got your bell on, It'll notify you, Malika. So I'm gonna go back just a little bit. And now, for anybody that's in here that did not watch for the last couple, hey, amazing. Oh, I hope you feel better. I hope you feel better, amazing. Um, for those who are in here today and have not watched or seen, thank you, amazing, or seen the my last two live streams. We reviewed, talked about, read all the motions in Carmelo Anthony's motion for a new trial. There were actually five motions. I think it was five, four or five. But yeah, I did read every word. Well, not every word. Oh, okay, girl. That's what I'm talking about. Well, first time here, however, I been on another platform. Okay, all right. So yeah, the last 2 days I've been reading the motions. I think I won't say it was five. Five motions that Carmelo Anthony's Dream Team presented in their motion for a new trial and for the judge's recusal. Today we're just gonna go through the remainder of that motion, which has the exhibits. Okay, listed in detail. We're gonna go with that. But I'm gonna back up just an inch. Okay, Miss Lee, no problem. You got your appointment. Praying for good results, Miss Lynn. Um, I hope I get some more mods in here, but if not, I'll be watching. We got amazing may be working, and then I had you. Oh, got keeper cute. I got my keeper cute. Hopefully, some more mods will show up. If not, I try to keep my eyes on the chat too as well. But you go ahead, Miss Lynn. Take care of your business, honey. Um. So yeah, I'm gonna back up just a little bit and review the ending of what we did on yesterday. I don't know why I clicked on that. Okay. All right. Which I thought was very powerful. And why is it not showing up? Oh. All right. Let's read. Let's read this prayer. Okay. And this is toward the ending. The five emotions that were listed, y'all. So let's get into it. Let me pull y'all up on this device. Make sure y'all double tap the screen. We got 87 in the building with only 13 likes. Make sure you double tap the screen to like the live, okay? All right, so prayer, right? Anybody got any questions, put them in the chat and we will, I'll try to answer them. Wherefore, premises considered. The court restricted the court restricted the general public, and the reason why I'm reading this prayer because it pretty much summarizes everything that we previously read, like all of the motions in this one paragraph, right? I know that's right. Amazing. Um, Wherefore, premises considered, the court restricted the general public to a 10-minute daily admission window and provided no contemporaneous alternative for those foreseeably turned away. Without the findings, while it requires, the resulting closure is structural error that a new trial is required to cure. Defendant Carmelo Sincere Anthony therefore respectfully prays that the court set this motion for an evidentiary hearing at which the facts concerning the closure of the courtroom, the delegation of the courtroom access determination to a non-judicial officer, the parties' unrecorded agreement limiting character evidence, and its repudiation and the preservation and harm facts concerning the unsupported provocation instruction. Those are all the motions summed up in one, may be developed. Grant the motion. Set aside the judgment of conviction and sentence. Order a new trial conducted in a courtroom open to the public. Enter written findings of fact and conclusions of law in support of its ruling, grant the relief requested in the interest of justice, and grant such other and further relief to which the defendant may be justly entitled. Good morning, Miss Carla. Good morning, sweetheart. Happy Friday. Okay. All right, so let's proceed. And this was written by Russell Wilson II, who is the first chair of the Dream Team. He's the lawyer on the Dream Team, and that's his information as well as all the other lawyers. Russell Wilson is lead counsel. Michael Ware is second chair. Gary L. Bledsoe is third. Brooke Cluse is co-counsel, and Sean Del Redia is co-counsel. All right. Justin A. Moore is co-counsel. And this is certificate of service. I certify that a true and correct copy of the foregoing was served on the Collin County Criminal District Attorney's Office, including counsel of record for the state, on July 6, 2026, through the electronic filing manager or electronic mail in accordance with the Texas rules. So basically what Russell is saying right there is the judge and the prosecutors have been served this motion. All right, thank y'all for the hearts. I appreciate it. I never really paid attention to that, but thank y'all for all the hearts. I appreciate that. Okay, Russell also wrote certificate of presentment. I certify that this motion for a new trial and brief in support was presented in the Honorable Judge presiding over the 296th Judicial District Court on the 6th day of July 2026, in accordance with Texas Rule of Appellate Procedure. Defendant has contemporaneously filed a verified motion to recuse to old boy, Cockroach. True, sorry, I wasn't here yesterday, but yesterday wasn't a good day for me. Was it good for my brother? Oh, I'm sorry, Miss Carla. I remember your brother. Oh, I'm sorry. I hope you feel better. That's okay that you wasn't here. I pray that you feel better. Miss Carla, it's okay. Pray for your strength, honey. Yeah. This presentment is made solely to satisfy Rule 21.6 and does not waive defendant's motion to recuse, does not constitute consent for the respondent judge to hear or rule on the merits of the motion for a new trial, and does not waive defendant's request that any evidentiary hearing or merits ruling occur only after the motion to recuse has been resolved. Now, basically, from what I understand, oh, thank you, amazing. Thank you, girl. Thank you. That's my baby lady. In fact, hey, roll her. Let me see if she would do that. Okay. So from what I understand, y'all, and I still got to get that document I told y'all I was gonna try. In fact, let me do something right quick. Let me do something right quick, y'all. In fact, I just put it in my device because I need to be reminding myself of stuff. Hey, Natasha. Hey, boo. Ooh. Okay. I told y'all I was gonna get that. What did I say? Oh, that document, the judge's refusal to recuse himself. So I gotta make sure when I come back. All right, so that's one of the things I promised. Now I did also promise that I was gonna put that letter up, but there's no need for that because that letter is in this document. So y'all gonna be able to see the letter in this document. All right, so let's continue. All right, so Exhibit 1, let's get into it. Exhibit 1. Make sure y'all double tap the screen to like the live stream. I would greatly appreciate it. Keeps us in the algorithm. This is Exhibit 1. Exhibit 1 contains amended or regulating trial proceedings, media access, security, and courtroom decorum with the order prohibiting extrajudicial statements attached. Okay? All right. What Miss Leah say? Miss Leah said you'll be a new next Friday. Oh, happy having a birthday to your brother, Miss Lynn. I love y'all, Miss Carla and Miss Lynn. All right, let's see. All right, this is excuse me, y'all. This is the state of Texas versus Carmelos and St. Anthony, and what this is the amended order regulating trial proceedings, media access, security, and courtroom decorum. Now, this is the order that the judge ordered. Okay, y'all. Now, remember when I say the court means the judge. All right. So this is the order that he ordered as far as trial proceedings, media access, security, and courtroom decorum. All right. On this day, the court enters this order to govern all aspects of the trial proceedings in this matter. Due to the significant public and media interest in this case, the court finds that specific procedures are necessary to ensure the defendant's right to a fair and impartial trial, the orderly administration of justice, the safety and security of all participants, and reasonable public access consistent with constitutional requirements. The court has considered the directive set forth in Waller. We've heard a lot about Waller, y'all. Set forth in Waller versus Georgia and Shepard versus Maxwell, as well as all applicable constitutional provisions, statutes, and case law. The court finds that this case has generated substantial public and media attention and that unrestricted access or activity may compromise courtroom security, juror privacy, and the defendant's right to a fair trial. The court further finds that reasonable time, place, and manner restrictions are necessary and appropriate, and that while the media and public retain the right to attend proceedings, such access is subject to the limitations set forth in this order. Now, mind you, as stated in this motion that we read earlier, the judge put this in place without having a hearing and without giving the defense or the state the ability to object to it. He just put it in place. He didn't do a hearing. He didn't do a conference. He didn't do anything. He just put this order in place right here, right? The courtroom shall open up each day, and this is a big part of the motion because what this judge put in place, this order right here, the Dream Team is saying it prohibited Carmelo from receiving a public trial, right? The courtroom shall open each day. Hold on. Oh, that's my mom. Give me a minute. I'm gonna play a little music right quick. I gotta call her right quick. Okay. Mars, please take over the chat. I'll be right back. I'm back, y'all. I am back. I apologize. I do apologize, y'all. I apologize. I don't even know if y'all. Let me see. Let me see something right quick. Child, when a deacon is called, you got to answer, honey. All right, but I'm back. I am back. Let's get into it, y'all. What y'all? Let me see what y'all writing in the chat. If y'all were writing, oh, okay. If he wasn't going to follow this, what the fuck did he submit it? Well, this is what he did follow. This is what they disputing, I think. Well, actually, no. He made one order, then he took it back. We're gonna read. I think this is the initial order he put into place, but I'm not for sure until I read it. Malika. Hey Danielle, how you doing? Good morning. So we're gonna see, Malika. We're gonna see which one this is, because you remember, initially he provided that overflow room. Remember, and then later on he snatched it away. And I don't know if he put that in an order or not, because I remember it being said that he didn't even announce it or anything. He just did it. Like, he allowed the overflow room for the first 2 days, which was the jury selection, right? And then he snatched it away. But I don't know if he put that in an official, like, written order or not. But we're gonna see, because believe me, they got it all in this motion. So we're gonna see. Let's read this one. Okay. The courtroom shall open each day of the trial at 8:30 a.m. Entry shall be permitted beginning at 8:30 a.m. for members of the media, at 8:40 for designated family members, and at 8:50 for members of the general public. No more than 9 members of the media shall be permitted in the courtroom at any one time. Seating shall be on a space available basis. The courtroom doors shall close promptly at 9 o'clock a.m. and individuals arriving after that time should not be admitted until a recess. Once admitted into the courtroom, no person shall leave and re-enter during proceedings except during a recess. The determination of who qualifies as a member of the media, which media representatives will be permitted access to the courtroom, and the allocation of media seating shall be made with the assistance of the court-appointed public information officer for the court. Media representatives must comply with all credentialing requirements established by that officer. The court would not intervene in or resolve disputes among members of the media regarding access or seating. The court has appointed Steve Stoller. Y'all remember that name? It's going to come up some more. Steve Stoller as the appointed public information officer. Now, what that is saying is that Steve Stoller was appointed by this judge to determine who was granted media access. Because remember, it's only 9 members of the media that were allowed. And this guy, Steve, was to determine who will receive media access, who will receive that media access, right? All right, so goes on to say, no person, including members of the media, shall photograph, record, or otherwise visually capture the image of any witnesses, prospective witnesses, juror or prospective juror. Now, nor shall any person publish or disclose the name, identity, or personal information of any witness who is a minor, a juror or prospective juror. No person shall communicate or attempt to communicate with any witness, prospective witness, juror, or prospective juror prior to the return of a final verdict. No interviews of witnesses, jurors, or prospective jurors shall occur until after the conclusion of the trial, and only if voluntary agreed to by the person. So basically, nobody could talk to, photograph, record, or visually capture the image of any witness, even though he had a whole sketch artist in there. He had a whole sketch artist in there, but he said nobody else could do it. Nobody else could do it. All right. Photography, video recording, audio recording, live streaming, or any form of recording or transmission of courtroom proceedings is strictly prohibited. No cell phones or other electronic devices will be permitted into the courtroom. Electronic devices may be permitted in the courtroom by the media for note-taking purposes only. So, if you were determined to be part of the media, those 9 people, uh, they were allowed to have an electronic device to take notes, subject to approval by the court, and must remain silent at all times. No media interviews shall be conducted in the courtroom, in the hallways, or in any security restricted areas of the courthouse. All interviews must take place only in designated areas approved by the court and coordinated with the assistance of the court-appointed public information officer. Media activity must not interfere with courthouse operations, security measures, or the orderly conduct of proceedings. All persons present in the courtroom shall remain silent and respectful at all times. No talking, gestures, facial expressions, emotional outbursts, or other reactions to testimony, rulings, or proceedings shall be permitted. Bullshit. Because we heard, okay? Now, this is from the media that we listened to at the beginning of this trial that stated Austin's mom verbally expressed herself many, many times. You can't tell nobody how to fix their face. That's one thing. That's this guy, he got to be some type of narcissist or whatever. You can't dictate how somebody express their facial expressions. That's one thing. For two, it was said that Austin's mom she verbally expressed herself on several occasions. Even jurors, members of the jury, cried during testimony. None of these people were removed. Neither one of them. Now, I guarantee you, had Carmelo mama bust out or said something, or the daddy had bust out and said something, they would have been put out. Or even the grandma. They would have been put out. But we're going to keep it pushing. We're going to keep it moving, right? All persons present in the courtroom shall remain silent and respectful at all times. No talking, gestures, facial expressions, emotional outbursts, or other reactions to testimony, rulings, or proceedings shall be permitted. No reading of newspapers, books, or other materials unrelated to the proceedings is allowed. No food, drink, or chewing gum shall be permitted, except as authorized by the court. All persons attending the proceedings must be dressed in appropriate business attire. Even the not business attire. Clothing or items displaying messages, logos, symbols, or images related to the case or that are otherwise distracting or potentially prejudicial or prohibited. Hats, caps are prohibited. No signs, banners, or this man crazy. Okay, or demonstrative materials may be brought into or displayed within the courtroom or courthouse. No member of the public or media shall be permitted beyond the bar separating the gallery from the intersection of the courtroom. That area shall be limited to counsel, parties, court personnel, law enforcement officers involved in the case, witnesses when called, jurors, and other individuals authorized by the court. The trial shall be conducted in a secure environment. All persons entering the courtroom shall be subject to security screening, including magnet meters and searches of all personal belongings. Additional security measures may be implemented as deemed necessary by the Collin County Sheriff's Office, other court security personnel, or the court. No weapons of any kind shall be permitted within the courthouse. Members of the public and media should not congregate in hallways, entryways, or other areas of the courthouse in a manner that disrupts operations, creates security concerns, or interferes with the movement of individuals. All persons must comply with the directions of court staff, security staff, and law enforcement personnel at all times. Order prohibiting extrajudicial statements or gag order. Order prohibiting extrajudicial statements or gag order signed July 28, 2025 will remain in force until the completion of the trial or until further notice. Until wait a minute. Order prohibiting extrajudicial statements or gag order signed July 28, 2025 will remain in force until the completion of the trial or until further order of the court. Order is attached for reference. As stated in the order, any violation may result in contempt, fines, attorney discipline, or other remedies as the court deems appropriate. So basically, was that saying the gag order that he implemented on July 28th? Because mind you, he implemented a gag order way back when this first started. When the case first started, before it went to trial a year ago, July 28th, he implemented a gag order. So the attorneys couldn't speak, the witnesses couldn't speak, the parents couldn't speak. No one can speak about the trial publicly, and he kept that in force throughout the whole trial. Any exhibits admitted during trial should not be released to the public or media until the conclusion of the trial proceedings. That's self-explanatory. Finally, as reflected on the attached map, the court has designated certain areas around the exterior um, the court has designated certain areas around the exterior of the courthouse as restricted access. These areas, colored in red, will be secured will be secured for courthouse operations and security and will not be open for use by the general public or the media. Furthermore, an individual or group shall not assemble or congregate in areas that block ingress, egress of vehicular movement or pedestrian traffic. Any individual or group engaging in speech activities on Collin County premises shall at all times comply with applicable federal, state, county, city, or other local laws, statutes, ordinances, regulations, or rules as detailed in the attached map. That's why when you will see the media outside, the people that were outside, you notice they were all back from the courthouse. Like you couldn't be right there. You couldn't be you couldn't be if you notice when they showed people they were all back away from the courthouse. Like you couldn't be right there in front of the courthouse. They had a section way back from the courthouse where people were, the media and everybody. Collin County Courthouse, located at 2100 Bloomdale Road, McKinney, Texas, shall be under a temporary curfew beginning May 31st, 2026. The curfew will be from 11 p.m. through 6 a.m. every day until further order of the court. Curfew means the designated time after which access to or movement within the entire Collin County Courthouse campus, including parking lots, sidewalks, green space, or any other designated area, are restricted from access. That meant that people couldn't camp out basically. Like, people were there like early in the morning to try to get into the courtroom since the spaces were limited. So basically between 11 p.m. and 6 a.m., no one can be on the campus at all. Any violation of this order may result in an immediate removal from the courtroom, courthouse, or courthouse grounds. It may result in revocation of media credentials or access, and the imposition of sanctions, including contempt of court. No warning is required prior to enforcement of this order. The Collin County Sheriff's Office and other designated law enforcement personnel are ordered to ensure compliance with this order at all times during the trial. This order may be modified at any time as necessary to ensure the fair and orderly administration. Now, this doesn't say anything about the that I remember about the overflow room. It just talks about the courtroom. It doesn't say anything about the overflow room. Let's see what this is upside down. It's basically just a chart of what we just read. The courthouse exterior operations and excess map. And that's a visual of the area. Yeah, that's a visual of the area. And you see right there with the, let me plug this damn phone up. I hate notifications. I don't even know why I got them on my damn devices. Notifications gets on my damn nerves. Notify you every damn thing. Battery low, screen dark, screen light. My God. Um, yeah, that's what that is. Mm-hmm. Now, this is the order prohibiting extrajudicial statements. This is a copy of the gag order, people. This is the copy of the gag order that was implemented on July 28th, 2025 at 9:57 a.m. Like I said, there has been a gag order on everybody in this case since the case began. Since Judge Roach got the case a year ago, there has been a gag order. And this is the gag order. We're going to read it. Number one, purpose and authority. The court finds that extensive pretrial publicity poses a serious risk to the fairness of the trial. Pursuant to the inherent authority of this court and consistent with the United States and Texas constitutions, the court orders the following. Number two, parties subject to order. This order binds the following individuals and entities, which means covered persons. So, all parties to this action and their attorneys, witness, expert, consultants, agents, and spokespersons, law enforcement personnel, courthouse, court staff, and court appointed officials. Those are all the people that were under this gag order. All parties to this action and their attorneys, witnesses, expert consultants, agents, and spokespersons, law enforcement personnel, courthouse, court staff, and court appointed officials, all were under the gag order. These are the prohibited activities. Unless first approved in writing by the court, no covered person shall make any extrajudicial statements that addresses the character, credibility, expected testimony, guilt or innocence of any party or witness. See, they had that little play in action about the credibility thing from day one. Y'all paying attention? They had that whole credibility thing or innocence or guilt thing mapped out from day one. They did. Pay attention to the words. Prohibited activities include discusses evidence anticipated to be introduced at trial, identifies or comments on jurors, jury selection or deliberations, intends or is likely to influence public opinion or potential jurors. These restrictions apply to statements made via any public medium, including traditional news outlets and social media. Permitted communications. Allow communications include, now this is what they could do. Procedural announcements, hearing schedules, court filings, statements required by legal or ethical duties, advising clients of rights. Court findings. The court finds media coverage has the potential to cause imminent and irreparable harm to the defendant's right to a fair trial. Alternative measures, venue change, juror screening, sequestration would be inadequate alone. They ain't do no bit well. Narrowly applied speech restrictions are necessary to protect on juror impartiality. Duration. This order shall remain in force until verdict or until further written order of this court. Sanctions for non-compliance. Any violation may result in contempt, fines, attorney discipline, or other remedies as the court judges appropriate. Notice of certification. Within 7 days of this order, counsel for each party should serve a copy on all covered persons and file a certificate of compliance confirming notice. So, the lawyers in the state was responsible for letting everybody know they were under a gag order. And from my knowledge, everybody they complied with the gag order. Nobody said a word until after the trial. Even the judge. Exhibit 2. Register of Actions. Public docket. Printed June 26, 2026. Now, I'm not going to read this stuff. Basically, what this is, y'all, is everything that happened with the case since June 26. As you can see, it's the state of Texas versus Carmelo Anthony filed by indictment. This form was started June 24th, 2025, which is when he first appeared in court, his first initial court appearance. And this is everything like dispositions, events and hearings, when he made bail, all that stuff is right here. Everything that happened from the time he got arrested up until the end of the trial. That's all that. I'm not going to read all that stuff. Yeah, I'm not going to read all that stuff. All right, let's continue. Exhibit 3. Verified transcript of the WFAA-TV interview of Judge John R. Roach with the authenticated affidavit of counsel. Good God, what a lot of subpoenas. Oh, yeah, it was a lot of... hey, Talker. It was a lot of subpoenas. A lot of subpoenas went out, but some of those people we didn't even see testify. It was a lot. But a lot of those people didn't even testify. You know what? Let me go back and see something. I'm glad you mentioned that. I'm glad you mentioned that. I'm glad you mentioned that. Let me see something. Y'all see all these subpoenas that were issued. Y'all know not even 90% of anybody. Look at all these subpoenas. I was hoping it would have names. But it didn't because I wanted to know who was subpoenaed and they didn't testify. Yeah, that's a lot. That is a lot. You're right. But we know didn't that many people testify. You see that? Keep it cute. Yeah, buddy. All right. So this is the WFAA TV interview. This is the transcript. Now we did watch that video. Actually, we watched it twice. I don't think I should have to read this. Y'all want me to read it? I will if y'all need me to, but we did watch the actual video. We heard, and talked about what he said. So y'all let me know real fast in the chat if y'all want me to read it. And I will. I will if y'all want me to. Let me know. But we did watch the video twice. Okay, no, great. Let me what's your name? Denisha, if you go to my live from yesterday, you'll see the actual interview. You can listen to it. It's on my live from yesterday. See, these people right here, they've been in every live, so I mean, we done listened to that video about 3-4 times. So if you go to my live on yesterday, you will see the whole. In fact, you will see two of them. Now they only mentioned one right here, but it's actually two of them, and both of them we listened to on yesterday. Okay, all right. I'm gonna skip through that. Skip through that. And then I think the next exhibit is gonna be where they sent the actual video to yeah, they got it all in here, baby. All right, so this right here, y'all, is the affidavit of Russell Wilson, who is Carmelo's lead attorney right now, authenticating exhibits to defend his motion for a new trial and motion to recuse. This is the attorney's written motion to for Judge Roach to recuse himself. Okay. State of Texas, County of Dallas. Before me, this is Russell Wilson speaking. Before me, the undersigned authority on this day personally appeared Russell Wilson II, who, being by me duly sworn, disposed, and stated, my name is Russell Wilson II. I am over the age of 18 years old and of sound mind, in all respects competent to make this affidavit. I have personal knowledge of the facts stated herein, and they are true and correct. I am the lead counsel of record for defendant Carmelo Sincere Anthony in the above styled and numbered cause. I make this affidavit to authenticate the following exhibits, each of which I have personally reviewed. The same exhibits are offered in support of both defendant's motion for new trial and brief in support, and defendant's verified motion to recuse, because the two motions number their exhibits differently. I identify each item by its designation in each motion. The recording, talking about the video. Motion for new trial, Exhibit 4. Motion to recuse, Exhibit C. After the televised interview of the Honorable Judge R. Roach, Jr. by WFFA TV, Channel 8, aired on or about June 11, 2026, I obtained and personally viewed a video recording of it as broadcast and published by WFAA TV. The video file is a true and accurate copy of that interview as broadcast and published, and it has not been altered, edited, or modified in any way. A copy of the recording is filed conventionally with the clerk of this court on a USB flash drive as an exhibit not amendable to electronic filing under a notice of conventional filing, and is designated Motion for New Trial Exhibit 4 and Motion to Recuse Exhibit C. The transcript, after obtaining the recording, I caused a written transcript of it to be prepared. The initial draft was generated with the assistance of transcription software. I then listened to the recording in its entirety and compared the transcript against the recording word for word, correcting each discrepancy I identified, and giving particular attention to the pages quoted in the motions. Based on that review, the transcript is a true and accurate transcription of the words spoken in the recording. The transcript is offered as an aid to the recording and not as a substitute for it. To the extent any discrepancy exists between the two, the recording controls. Basically saying if there's a discrepancy between the transcript and the recording is right. Hold on one second, y'all. Okay. The order prohibiting extrajudicial statements. The document so designated is a true and accurate copy of the order prohibiting extrajudicial statements. The gag order, signed July 28, 2025, and filed in this cause, which I have reviewed. The statement to Fox News: I personally observed and reviewed the written statement of the Honorable Judge R. Roach, Jr. to Fox News concerning this cause. The document is so designated is a true and accurate copy of that statement as published, which I have compared to the statement as published. The public letter. I personally accessed, observed, and reviewed the public letter to the Honorable Judge R. Roach, Jr. entitled "Thank You Letter from Judge John Roach," dated June 17, 2026, as published on the official website of Collin County, Texas. The document so designated is a true and accurate copy of that letter as published on the county's official website. All right. Exhibit 4. This is a video filed conventionally on USB. This is the verified transcript of okay. That's okay. So the USB, which had the interview on it that they provided is Exhibit 4. That's basically what they're saying. That Exhibit 4 is that USB with the actual interview on it. That's it. That's all right now. So Exhibit 5, written statement of a written statement of John R. Roach to the Fox News. Now this is what Judge Roach wrote to Fox News. It's on Brooke Taylor's Facebook page, whoever she may be. Judge John Roach tells me he released the evidence because this is Brooke speaking on her Facebook saying the judge told her he released the evidence because this is after that video came out. Remember, y'all, the video that everybody thought was going to show what happened and it didn't. He said, I understood the public's desire to know what happened in the courtroom. The overwhelming focus on my ruling regarding the media in courtroom was to protect the process, the witnesses, and the jury. Now that the trial is over, it is important to me to provide transparency. Yeah. I'm gonna read that one more time. Now this was after the case was over, y'all. And she asked a specific question, but his answer doesn't really answer the question to me. The question was, why did you release the evidence? Right? He said, I understood the public's desire to know what happened in the courtroom. That didn't happen in the courtroom. The overwhelming focus on my ruling regarding the media in the courtroom was to protect the process, the witnesses, and the jury. Now that the trial is over, it is important to provide transparency. Oh, okay. So basically, he released the video to show transparency, but you ain't released what happened in the courtroom, though. You refuse to release what happened in the courtroom. These people still don't have a transcript of the proceedings in the courtroom, so that's bullshit. Moving on. But that was admitted into evidence, y'all. All right, so Exhibit 6. The thank you letter from Judge John Roach dated June 17, 2026. And this was on the Collin County website. Letterhead and all. Letterhead and all. He says, as the presiding, and I read this once before, but I read it again. I read it maybe 2 days ago. As the presiding judge of the 296th District Court during the recent trial of State of Texas versus Carmelo Anthony, I want to express my sincere gratitude to the countless individuals and agencies whose professionalism, dedication, and cooperation made it possible for the court to fulfill its most fundamental responsibility, ensuring the fair, orderly, and secure administration of justice. Trials that attract significant public attention require extraordinary preparation behind the scenes. While much of the public focus on naturally directed towards what occurs inside the courtroom, the truth is the work of administering justice depends upon the collective efforts of many people, most of whom serve quietly and without recognition. I extend my deepest appreciation to the Collin County Commissioners Court for its unwavering support and commitment to ensuring that the resources necessary to conduct this proceeding were available. I am equally grateful for our budget department, information technology department, human resources department, auditor's office, CSCD, public works, and facilities department, each of which responded to the challenges with professionalism, flexibility, and a willingness to do whatever was necessary to meet the moment. I offer special thanks to the district clerk's office, and jury services staff for their tireless efforts in managing the enormous logistical demands associated with jury selection and trial administration. Their work ensured that citizens called to serve were treated with dignity and respect throughout the process. Okay. I also wish to recognize the extraordinary efforts of the Collin County Sheriff's Office, whose deputies and leadership devoted countless hours to maintaining the safety and security of all participants while preserving the integrity and decorum of the judicial process. My gratitude extends to the Texas Department of Public Safety and to our law enforcement partners from the McKinney, Allen, Frisco, and Plano police departments. Their collaboration, planning, and visible presence provided reassurance and protection to all who entered the courthouse. I likewise thank the Collin County and McKinney Fire Marshal's offices for their expertise and assistance in ensuring that appropriate safety protocols and emergency preparations were in place. I would also be remiss he'll go he'll go. I would also be remiss if I did not recognize my fellow judges of Collin County. Throughout these proceedings, they modified already demanding schedules, adjusted their own dockets, and accommodated the unique needs of this case without hesitation. They understood that ensuring the orderly administration of justice in one courtroom often requires sacrifice and flexibility throughout the entire courthouse. Their willingness to loan members of their staffs, including their invaluable bailiffs, provided critical support and exemplified the collegially professionalism and spirit of service that define our judiciary. I am deeply grateful for their friendship. Oh, not their friendship, cooperation, and steadfast commitment to our shared mission. Most personally, I want to recognize the remarkable staff of the 296th District Court. Their long hours, attention to detail, patience under pressure, and steadfast commitment to public service were indispensable. They represented this court and this county with excellence. Okay, Truth, I'm off to work. Trying to stop by once I get. Okay. All right, Taka, thank you. Have a good day at work. Finally, to everyone else who played a role, whether through planning meetings, operational support, communications, security preparations, technical assistance, administrative coordination, or simply a willingness to answer the call when needed, please know that your contributions matter. The public often sees only the final product. I had the privilege of witnessing the countless acts of professionalism and teamwork that made that final product possible. The administration of justice is one of our community's most solemn responsibilities. This trial demonstrated what can be accomplished when dedicated public servants from different offices and agencies work together towards a common purpose. Regardless of title or assignment, each of you contributed. Keep it cute. Question, if you're still in the chat. You got bad weather? You got bad weather? Um, no? Oh, okay. Regardless of title or assignment, each of you contributed to assuring that the process was conducted fairly, safely, and with the dignity of our citizens deserve. It has been one of the great honors of my judicial career to serve alongside individuals of such character and professionalism. On behalf of the 296th District Court, thank you for your service, your sacrifice, and your unwavering commitment to the people of Collin County. Sincerely, Judge John Roach. Okay, Exhibit 7, email of Steve Stoller, Corner Appointed PIO to Thelma Anderson. Now, remember who Steve Stoller was. He is the, now I gotta get his title right. I gotta get, and I told y'all, I remember his name, I just don't remember. And they got the initials. So damn it, and I'm not going all the way back up. He was the public information officer. That's what he was. Steve Stoller. I think that's what they stand for. Steve Stoller, public information officer. That's who he was. Him and Liquor said media somebody. He was the public information officer, right? He handled all the media as far as getting into the courtroom. He handled all that stuff, all that stuff, right? So this is an email to Thelma Anderson. Now remember, Thelma is a person. I don't know if she's a news bar. I don't know what her title is or whatever, but I do know she was in that courtroom or attempted to get in that courtroom during the trial. I do know that. I don't know if she's part of the media or if she's just a regular smuggler, right? But this is an email from him to her on Friday, June 5th, 2026 at 8:31 p.m. And the subject was Anthony trial media coverage. And he says, oh, she's an ex-attorney? Oh, okay. All right, I didn't know that. All right. So he says, hi, Thelma. My name is Steve Stoller. The 296th District Court appointed yours truly as the public, and he misspelled words. That's okay. Steve. The 296th District Court appointed yours truly as the public information officer for the Anthony trial. I wanted to take the time to explain the process we followed for media coverage. To set the stage, there are only about 70 seats in the courtroom. Obviously, with so much interest in the trial, both locally and nationally, it is literally impossible to accommodate everyone. The prosecution gets 15 seats for family members. The defense gets 15 seats for their family members. The judge allocated only 9 seats for the media, including 1 for a courtroom sketch artist. So the media didn't even have 9 seats; they had 8, to be honest. Add court staff, and that leaves about 2 dozen or so seats for the general public. As much as we dislike turning people down, we had no choice. So basically, he sent her this email, I guess, after maybe she had been turned away. The Collin County Public Information Officer established an application process more than a month before the trial started. Then he left the county. I came in to pick up where he left off. The deadline for applications was May the 20th. We received requests from all over the country from major media outlets, local media, and a long list of social media influencers. We chose 8 media outlets for credentials on May 21st. We included the local television stations and newspapers who cover. Excuse me, y'all. Let me just hold on 1 minute. So basically, y'all, what I'm seeing so far is that they even chose what media to let in. Like, they didn't just let, all media outlets were about. They even chose which media outlets they let in. And they telling you right here that it was mostly people from Collin County. Let's read. We chose 8 media outlets for credentials on May 21st. We included the local television stations and newspapers who cover Collin County courts on a regular basis. So with that being said, the media that they let in, the 8 media outlets that they let in were all from Collin County, which, if you think about it, is not a diverse. They like all of them from Collin County. We know the people from Collin County was for who? The state. Want none of them people for Carmelo. So you got all these media news stations in there that's basically against Carmelo, who's reporting on this. You know what? I tend to agree with you, Malika. I tend to agree with you. Well, Court TV was in. Well, Court TV had a black dude. He was an Uncle Tom, but he was black. He was in there. Hey, D Truth TV, how you doing? Good to see you. He was in there. We included the local television stations and newspapers who cover Collin County courts on a regular basis. We felt that was the fairest route to take. Fairest route to take. We invited media members who were not approved for credentials to gain access with the general public on a first-come, first-served basis. We encouraged them to get in line early. Many of them, including some very well-known names in the media world, like the New York Post, the Washington Post, and NBC News, waited in line with the general public and gained access to the trial. So basically, the 8, that's weird. Like the 8 media outlets that they approved to come in every day that was guaranteed to get in were all from Collin County. And then the national people like NBC, New York Post, Washington Post, they had to stand in line with the general public and wish wish and pray that they got in. Oh yeah, we've been yeah, we've been following all that. Go back in my content, you'll see it. We've been following this since it happened, since back in July of 2025. This right here, what we read right now, D Truth TV, is the motion that the 6 attorneys filed for a new trial and for the recusal of Judge Roach. This is the motion right here. I actually read the motion over the last 2 days. This right here is just the exhibits that were presented in the motion. So yeah, we've been covering all of it. Dang, he was being biased. Yes, he was being biased with the media too, because this is the thing. If you got 8 spots, right, why not give 4 to your Collin County people and then give the other 4 to the national news? Why are you just giving the guaranteed access to people from Collin County? How many news outlets from Collin County do you need? If you wanted to represent Collin County news, you could have gave 4 of those spots to Collin County, right? And you could have gave the other 4 to national news. Let's be clear. This man knew exactly what he was doing, y'all. I'm going to be honest. Like, he knew exactly what he was doing. He's a true narcissist that's used to controlling everything in real life, right? And he did everything in his power to control everything about this trial. Everything. And putting these rules and regulations in place, that was his way of doing it. Even if he broke the law doing it, he didn't care. He's a narcissist. He don't care. And he feel like he's untouchable. You know, the same way he set up in that interview the day Carmelo got sent off with that smug look and that pompous attitude. That's him. That's how he is every day in real life. Yes, keep it cute. Yes, the truth. Yes. This man strategically set this up the way he did. And he even said it in that interview. He said, I've been prepared for this case for 10 months. 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 10 I've been preparing for this for 10 months. And he took them 10 months and he devised the plan. Him and those prosecutors. Don't forget about them. Don't forget about them. Because at this point, y'all, and we hadn't gotten to it yet, but we almost there. So stay tuned. I think Mike Howard was not, listen, I changed my stance. Keep it cute. Natasha, Malika, I haven't read it yet. But I got a feeling in my shanana that Mike, I keep wanting to say Mike Jones. Mike Jones, no, not Mike Jones. Mike Howard is going to be vindicated. I got a feeling. Yeah, that's right, The Truth TV. I got a feeling Mike Howard going to be vindicated, but we're going to get to it. Okay, let's continue. I'm sorry. This is still the email to Thelma, y'all. I'm sorry I can't be more positive about securing a media credential. I wanted to explain how we got to where we are. I hope you understand. Warm regards, Steve. So basically what Steve was doing there, because apparently Thelma must have emailed him, right? You haven't? Okay, what you probably need to do is go unsubscribe and subscribe back and hit the notification bell and make sure you hit all. But unsubscribe first. But make sure you subscribe back and then hit the notification bell and make sure it says all. Natasha, I already know you ain't going, boo. Listen, Natasha, I'm ready today. I already know you're not going. It's okay. I'm going to still read it and we're going to talk about it, okay? All right, so Exhibit 8. Credentialer and access emails redacted, arranged chronologically, da 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 da. Now, I wonder what this entails. Let's see. So this right here was the initial courtroom access email correspondence. So this was Truth I Relieve Receipts. Okay, we're going to see if he got something in him. This right here is the initial courtroom access email correspondence. This is the original email that was sent out as far as courtroom access, right? And let me see if is it worth reading. Yeah, I'm not gonna read that. What I'm gonna do is I'm gonna stroll slowly through it, and if y'all want to go back and catch the replay and like screen, like stop it and read it. This is basically talking about the access that certain people had, and I'm not gonna take the time to read all of that, but y'all can go back and read it if you want to. But basically, what this is showing on the most important part I'm gonna take out of this right here is on May 29th, 2026, there was an overflow room. There was an overflow room and live feed announced for the public, right? Through the PIO officer, Steve. So listen to this, because y'all remember that overflow room was taken away. So that's the most important part I'm going to take out of this little piece right here. Overflow room and live feed announced for the public on May 29th, 2026. This was right before the trial. The PIO announced, who is Steve, announced that the general public would watch a live feed of the jury selection process from the ceremonial courtroom, television monitors, audio provided, pen and paper notes permitted, and that once, wait a minute, and that once testimony, where's the rest of it? I don't see the rest of it, because we know now that overflow room was provided for jury selection, but once jury selection was over, it was snatched. When testimony started, it was snatched. So, but I don't see that in this little notation right here. But let's continue. Exhibit 8A. Maybe that's breaking it down. Let's see. Oh, that is the media. They put a copy of the media request intake trial coverage form right here. That's what people had to fill out. Um, Exhibit 8B is the credential process was changed. The credential process was changed midstream. Applicants were told prior submissions had not transferred. So they switched it up. And let's read this. Updated media credential submission. Action required for state versus Carmelo Anthony trial. 4 messages. Derek Jackson's to public relations. Who is Derek Jackson? Dear media representative. And this was put out Wednesday, April the 29th, 2026. Hey, Lanier. Good to see you. Thank you for the flowers. Dear media representative, you are receiving this email because you previously submitted a request for media credentials for the upcoming state. Oh, okay. So I guess this person right here had requested media credentials. We are writing to inform you of an important update to our credentialing process. While we previously accepted submissions through a Google form, we have since implemented a new internal system to better manage and process media credentials. Please note this message is not a confirmation of credential approval. Your request is still under review. However, in order to move forward in the consideration process, we require all applicants, including those who have already submitted, to complete the new internal form. It is important to understand that information submitted through the original Google form has not transferred to this new system. As a result, failure to complete this updated form may result in your application not being considered. Due to the volume of requests in the upcoming trial date, we ask that you complete this form as soon as possible to ensure timely review. Please use the link below to provide your information. And this is from Derek Jackson. He's the government information coordinator. So they updated the form, basically what this is saying. They started out with one form. Read the 14th Amendment. Why should I? What's up? We talked about the 14th Amendment. It's the right to receive a fair trial. I think it's a fair trial or for a public trial. Hold on. I usually don't take the instructions from the chat, but let me see what you want to. Truth I Wonder says the judge is now in the hot seat. Will they put his retirement benefit on hold until he is clear? I don't know, but that's a good question. That's a good question. I want them to get him before he retires. I do. All right. That's due process. So the 14th Amendment states, granted citizenship to all persons born or naturalized in the United States, including formerly enslaved people, and guarantee all citizens equal protection of the laws and due process. The amendment contains 5 sections, with Section 1 containing its most heavily interpreted and debated clauses. Citizenship clause established that all persons born or nationalized in the United States and subject to its jurisdiction are citizens. These overruled the 1857 Dred Scott Supreme Court decision that had denied citizenship to Black Americans. Due process clause prohibits state and local governments from depriving. This is the one right here, the main one that we should focus on. Due process prohibits. Lanier said that means they violated all of Carmelo rights. They didn't know that people were going to go deeper. That's true, Lanier. I believe that. Yeah. This is the main one, the due process. This is the main one that they're saying Carmelo was cheated out of. So due process clause prohibits state and local governments from depriving any person of life, liberty, or property without due process of law. This clause has been used to apply most of the Bill of Rights to the states through a legal concept called selective incorporation. The Equal Protection Clause forbids states from denying to any person the equal protection of the laws. This has been foundational to landmark civil cases such as, including Brown versus Board of Education. We know about that. So basically, they're saying that Carmelo was not granted due process, which is true. Very true. Yeah. All right. So what we got here? Okay. So this is. So we know that Derek Jackson is. He was over the. I'm thinking though, because I thought. Oh, you know what it is? I was confused for a minute, y'all, but here we go. Remember, Steve stated in that email to Thelma that someone else had been the public information officer, remember, before him? And he had just gotten into that position. So apparently, Derek Jackson was the first one. Apparently, Derek Jackson was the first public information officer, the one that left the county. He was the initial PIO before Steve. So this right here, which was put out Wednesday, April 29th, 2026, was before he left. So before he left, he updated the form, right? Derek Jackson, Government Information Coordinator. Yeah, that's him. So Nick at Night, okay, also wrote Derek Jackson on Friday, May 8th, 2026. At 1:30 p.m. And she says, I know I keep asking you about StreamYard, but I want to express it verbally where y'all can hear me and understand it. What you want to know about? What you want to know about StreamYard though? Did you want to hit a link or something? Did you want to come up on the link or something? Because I can get you up here without StreamYard if you want to come up. So Nika Knight wrote, this is when Derek Jackson was still the PIO. Friday, May 8th, 2026 at 1:30. And she says, I'm reaching out for a quick status update on my media application for the Carmelo Anthony trial that begins on June 1st. She says, as I finalize my travel and lodging for Nick at Night, I also wanted to ask for the court's latest estimate on the trial's duration. This will help me ensure my logistics are fully secured for the entire proceeding. She says, thank you for your assistance. Best regards. And then she put her name, which they blacked out. Shout out to them. Nick at Night, because we only know her as Nick at Night, right? So apparently he wrote back at 1:30 p.m. that same day. He wrote right back, actually. If you have the link, I can come up if you don't mind. I bet Derek was black and they let him go because he was going to let the. You know what? I was thinking it was something up with that. Lanier, listen, let me say this to you. I'm not gonna have a panel today because I want to get through this so I can get to my next live. But I promise you, when I come back on this, I will provide a link for you to come up. Is that okay? I just wanted to get through this little portion of this motion today because I have a whole lot of updates on the Nolan Wells case and the Javea Harris case. So I'm supposed to start that live at 12. So I wanted to get through with this today by 12 so I can go over to that live. So if it's okay, when I come back on this, you can hear, I'll provide a link. Is that okay? Malika, to what you just said, I thought it was pretty strange that this man left right before this trial started. Now Derek Jackson, you know, we know a lot of Dereks in our culture, right? He could be black. I don't know. Hell, he could be white. I don't know. Yeah. But I found it odd that he left the county, you know, like right before this trial started. But look, that don't mean anything, Malika. We got to stop being so suspicious of people, right? All right, y'all. So Derek Jackson wrote Nicki at Night back and said this. I am reaching out for a quick status up. Well, that's what she wrote. All right, I got to go back to what he wrote. Hold on. He said, because he wrote her right back like a minute later. No problem, love. It's all good because we're going to get to the bottom of it no matter what. Yes. Thumbs up for we have to do. Okay. I got you. Lanier. I appreciate that. All right, let's see what Derek wrote to Nick at Night. The courtroom was made available today to local television affiliates solely for the purpose of capturing footage of the empty courtroom for potential use during the upcoming trial. The courtroom is empty during this designated window, and all access was coordinated directly through the judge's bailiff. Me too, girl. To avoid any confusion, this was not an open access opportunity, nor should participation today be interpreted as an indication that any media outlet has been selected or approved for trial credentials. No credentialing decisions have been made at this time. The deadline to submit credential requests remains Wednesday, May the 20th. Final credentialing decisions will be communicated on Tuesday, May 26th. I hope this helps clarify the process and timeline moving forward. So he wrote her back and let her know, look, just because some people were allowed into the courtroom today, it was only to get pictures, and we have not yet determined who is gonna receive media assets. That's basically what he told her back in that email. All right, so this is media access allocation. Steve Stoller, a court-appointed PIO. The judge allocated access to 9 members of the media, priority to legacy outlets. Non-approved media were directed to the general public line. First come, first serve. All right. So, Steve Stoller, which is the PIO, sent this email out on May 20th, 2026. This is all before the trial started at 8:09 a.m. He says, dear friends, the 296th District Court in Collin County has appointed yours truly as court-appointed public information officer for the upcoming Anthony trial. Please read the attached order regulating trial proceedings, media access, security, and courtroom decorum. It clearly details the court's rules and protocols for the trial. As you know, courtroom space is extremely limited. As a result, the judge has allocated access to 9 members of the media. That said, many of you who applied for access were not approved. We gave priority to legacy media outlets who cover Collin County and our courts on a regular basis. That was a little prejudice to me. Like, they shouldn't have done it. I already explained why I felt like they shouldn't have done that. You got one Collin County news station, you got them all. So you just giving all those 8 spaces to Collin County, that was ridiculous. That was absurd, because we all know that all of you people of Collin County work together in this trial. The judge pretty much solidified that with that thank you note. All of you Collin County people work together, so it should have been at least 4 national news stations to cover that trial from the inside. I stand on that. They all work together. Everybody in Collin County worked together to do what they did to this young man, and I stand on that. The following organizations are approved for trial coverage. Those of you who were not approved for media access do have the ability to watch the trial as a member of the general public. Hey, Sonya. Seating for the general public. Right, Funberry. I mean, keep it cute. That makes sense. Seating for the general public is on a first come, first served basis. Doors will open at 8:50 a.m. for the public. If a media outlet attends as a member of the general public, then the general public rules apply. See attached court order. So the ones that were approved were Associated Press, KDFW-TV, KXAX-TV, WFAA-TV, KTV, KTBT-TV, Dallas Morning News, Community Impact, the Daily Mail, and the Sketch Artists. So biased. I call that biased. Yup, I do. Okay. Let's move on. Exhibit 8D. The credential call was presented publicly as a general call for credentials, then limited to established legacy outlets. Yup. Um, I don't know who wrote this or what this is. Let me see if I see a signature somewhere. Somebody wrote him back. Somebody wrote him back, but they're not showing who wrote him back. So when Steve sent out that email that I just read, somebody wrote him back and said this. Let's make sure. I want to be sure. I want to be sure. I don't want to confuse nobody. 7126. Yeah, somebody wrote back and said this, but it's not saying who wrote it. It says, while I respect the court's desire to work with established media partners, I have to be candid. The application process was presented to the public as a general call for credentials. It is difficult to understand why independent journalists were invited to apply if the selection criteria were strictly limited to legacy outlets with a pre-existing history at this courthouse. Amen. Amen. Many of us spent time preparing our credentials under the impression that the selection would be based on professional merit rather than a pre-existing footprint on this specific district. Whoever wrote this, amen. Did Derek study up? I don't know. I don't even know. As as I still intend to cover these proceedings thoroughly, I want to ensure, unless this is Neeks, I don't know. I want to ensure I am fully prepared to operate as a working professional within the public gallery. To that end, can you please verify a few logistical points? Electronic devices. The court's order stipulates that electronic devices may be permitted for note-taking purposes, subject to approval by the court. What is the formal procedure for a working journalist in the public gallery to secure this approval so that I may use a tablet or a laptop for silent note-taking? So this person wanted to know, y'all said that the 9 people that were approved as far as the media were allowed certain devices to take notes. This person is saying, I wasn't granted media access, but I will be in there as the general public, right? And I want to know, what can I use to take notes? That's what this person is asking. And then it says curing protocols. Having covered numerous high-profile trials, I know that unstructured first come first served public queues for high interest cases frequently devolve into disorder when there is no objective system to verify arrival order. Disputes are common. Given the heightened racial tension surrounding this specific case, I am concerned that an unmonitored queue could create a flashpoint for confrontations that compromise courthouse security. To ensure we remain compliant with the rules prohibiting hallway congregation, what specific protocol will prevent the chaos often associated with unstructured entry? And then they say information access. As an independent journalist, I am committed to fair and accurate coverage. Is there a process or distribution list where those of us not granted media status can still receive press releases, schedule changes, or logistical updates throughout the trial? My goal is to be a well-prepared observer who provides accurate reporting while respecting the decorum of the courtroom. I appreciate your time and your guidance on how to navigate these logistics. Best regards. And I don't know if that's from Nika Knight or no. I just don't know. I just don't. Somebody wrote Derek Jackson May 20th and said, that's the same thing I just read right there. That's the same thing I just read right there. And it got blacked out who sent it. The person that sent this, Didn't want their identity in here. Yeah. So it got them blacked out. There will be no overflow room during trial. Uh, this is Exhibit 8E, overflow room eliminated. That's where they eliminated the overflow room. Okay. Oh boy. Logistical compliance and public gallery security inquiry. State versus Anthony. 11 messages. To this was written to Steve, May 25th, 2026. Who wrote this? Nick and Knight wrote this. Nick at Night wrote to Steve and said, I am writing to request a direct, individualized response to three critical logistical items regarding the State versus Anthony trial proceedings, which I am covering on the ground for Nick at Night. Because of your recent broadcast updates were sent to a general distribution list, they left several operational questions unanswered for independent journalists operating from the public gallery. Number one, electronic device approval. Per Section 2, Page 2 of the Court's amended order, electronic devices are permitted for note-taking purposes subject to approval by the court. As a working journalist sitting in the public gallery, what is the exact formal mechanism to secure this specific judicial approval prior to Monday morning so I can utilize my laptop or tablet silently? She says, overroom access. Line 19 of the county's official media request intake portal explicitly allows applicants to request overflow room access. Is the court actively utilizing an overflow room with a live video audio feed for this trial? If so, what is the procedure for independent media to access it? Then she says, given the high profile nature and high intention surrounding this case, an unmonitored first come first served public queue presents a distinct security vulnerability. What specific protocols are the court and the Collin County Sheriff's Office implementing to monitor the morning line, verify arrival order, and prevent disorder outside the main entrance? As my travel and logistical footprints are fully finalized, I appreciate your immediate direct answer to these items so I can ensure absolute compliance with the court's decorum. That was from Neek at Night. He wrote back and said, Neek, I apologize for the delayed response to your specific questions. I will get them answered as soon as possible. There will be no overflow room during the trial. This was May 25th. Listen, people, this right here is evidence that even though they had that overflow room for jury selection, they knew that they wasn't going to have an overflow room for the... Listen. Y'all know right here what this email proves. If y'all still paying attention, I don't know if y'all are. This email from Nick at Night. This response she got from Steve Stoller on May 20. Mind y'all, the trial didn't start to June 1st. Right? The trial did not start until June 1st. Nick at Night got this response from Steven Stoller May 25th, 2026. And he told her in this email that there would be no overflow room. But when they started the trial, there was an overflow room for jury selection. And the media thought that there was going to be an overflow room, which was on that form, that it was going to be an overflow room for the trial. Hold on, y'all. Damn it. Hold on one second. I'm sorry, y'all. I'm back. I had to answer that, honey. That was my baby girl. Okay, y'all. My mood might get a little better because I was waiting to hear from her. I ain't hear from her early this morning, honey. Apparently, she slept in. She's a partying machine right now. Hold on a minute, y'all. All right, y'all. Let's see what y'all saying. Mm, okay. So, um, damn, what was I saying? Oh, yeah. Back to this. So this right here on May 25th, y'all. The trial started June the 1st. So on May 25th, this Steve Stoller person knew that there was not going to be an overflow for the trial. Do y'all know what that means? Right, Lanier. Does any He said, I apologize for the delayed response for your specific questions. I will get them answered as soon as possible. There will be no overflow room during the trial. Thank you for your patience and understanding. So Steve and them knew that there was not going to be an overflow room for this trial. Yet they had the people thinking there were. Not because it was on that form and it said that there were, but because the first 2 days of the trial. Now, why would the judge allow the overflow room for the jury selection, but not allow it for the rest of the trial? What in the hell sense did that make? And they knew they was gonna do it that way because as of May 25th, this guy told Neek it wasn't gonna be an overflow room. So they knew it wasn't gonna be an overflow room. But my thing is, why provide the overflow room for jury selection, but not the rest of the trial? They knew what they was doing, man. This is, you know what? I can't. I can't. As per Judge Roach, those who do not have media approval and gain access with the general public do not take approval. What? Do not have approval to take notes. So you couldn't take notes. Wait a minute. Hold on. Hold on a minute, y'all. My grandbaby tearing some shit up. Um. So this is Steve. Steve Stoller wrote back, and I don't know if this was Tanika or what, but we'll see. Yeah, it says Neek. Question number 3 should be directed to the Cullen County. This is him writing back Neek at night and saying her question number 3 need to be directed to the Collin County Sheriff's Office. They are responsible for security at the courthouse. So basically, her question that she asked about security and things of that nature, he told her to direct it to the Collin County Sheriff's Department. And then it looks like she wrote him back and said, yeah, it looks like she wrote him back and said, Hi, Steve. Thank you for confirming that there will be no overflow room utilized for this trial. Hey, Miss Beverly. Not to mention what happened to the rest of the seats for the family. Oh, not to mention. Right, Sonia. What happened to those other seats? What did happen to those other seats, right? That you right. I didn't even think about that. Maybe it's in here. I don't know. We'll see. Because I'm going to read every word of this. Hold on 1 minute, y'all. Okay, y'all. Let's go. So, Steve I mean, Nick at night wrote Steve back, right? Dolores, what did she? Let me see what that message said. Y'all making stuff up. You know what? Thank you, keep it cute. And if I want some nose, I wouldn't have saw that. You got it before I saw that dumbass comment because how are we making something up when this shit is in black and white? Keep it cute. Can you answer that? What are we making up when we read black? See, this is why. You know what? This is education versus ignorance, right? So this is why I read stuff. This is why I put stuff up on my screen. I don't just read shit and don't put it up. Right? This is why I do it the way I do it for people that don't know. This is the reason why I play videos. I put up screenshots. I put up, take the time to go look for shit myself and find it and put it up. Because you got ignorant people that come in here saying something is made up. This shit is in black and white. So you take your dumb ass over to a platform that makes shit up. Because I don't do that over here. There's no need for it. Now, moving on. So Neek writes back and says, shout out to Neek at night because she was very professional with everything she did from what I can see, right? Thank you, keep it cute. Girl, I can't. You know how ignorance perturbs me. It perturbs me. You know me. Oh, anyway. Nick said, hi, Steve. Thank you for confirming that there will be no overflow room utilized for this trial. I look forward to your upcoming response regarding the formal mechanism for securing the court's note-taking device approval per Section 2, Page 2 of the order. Sergeant Pond, per PIO Stolar's directive below, I am directing question number 3 to the Collin County Sheriff's Office. Given the high-profile nature and heightened public tensions surrounding the State versus Anthony trial, what specific protocols is the Sheriff's Office implementing to monitor the morning public queue outside the main entrance, verify arrival orders starting at the 6 a.m. curfew lift, and prevent potential disorder before the doors open up at 8:50 a.m.? Since there is no overflow room, who comes first and honoring first come, first serve is crucial. How would this be handled to verify the safety of those of us standing outside in the line for hours? As an independent journalist managing on-the-ground coverage, I appreciate your insight into these safety measures so I can coordinate my team's arrival safely. And this is from Nick at Night to Steve, right? They don't care about the truth. A black boy unalive a white boy in self-defense, so they don't care. If they think we're making something up, they need to go make their own bed. Make up that. You know what? That's right, Lanier. I'm not even gonna worry about that. I'm gonna keep it pushing. The Collin County Sheriff's Office does not discuss security protocols, processes, or procedures. Wow. All right, so right here. This email is from, I don't know, because they blacked their name out. But it's to Steve. And the subject is urgent. Logistical compliance and public gallery scrutiny inquiry, State versus Anthony. This was sent May 26, 2026 at 7:48 a.m. And it states, the Collin County Sheriff's Office does not discuss security protocols, processes, or procedures. Thank you. So basically, the sheriff said, we're not going to tell y'all how we're going to protect y'all if we protect y'all. They don't disclose. So Nika and Knight wrote Steve again and said, hi, Steve. Understood on the electronic devices and laptops. To clarify on the note-taking itself, does Judge Roach's directive prohibit traditional pen and paper note-taking by members of the public gallery as well? Or are physical notebooks and pens permitted inside? I want to ensure absolute compliance with the physical decorum of the room on Monday morning. Nika at Night wrote that to Steve. Exhibit 8H is note taking is only allowed for approved media. Followed 2 days later by you will be allowed to take notes with pen and paper during the trial. So Steve wrote to I don't know who this person is at Tuesday, May 26th at 8:40. Their name is blacked out. This might be Neek. When I say name blacked out, I know what that is. All this is Tanika Knight, but it's got her real name blacked out. All these emails are to Nick at Night, but it's got her email. I mean her government name blacked out. And he wrote her note taking is only allowed for approved media. Now that was sent on May 26, 2026 at 8:40 a.m. And then she got another email May 28th, 2026 at 8:02 a.m. 2 days later. And he wrote, "Hi Neek, I have an update for you. You will be allowed to take notes with pen and paper during the trial. Warm regards, Steve." And then Steve wrote her again May 26th at 10:40 a.m. Well, that message was at 10:40 a.m. I guess. Neek wrote, "Damn, they got a lot of emails, man." She wrote, "Hi Steve, thank you for the update and the clarification on the note taking protocols. I appreciate you looking into that for me. See you at the courthouse." He said, "Looking forward to meeting you, Neek." Steve was kind of okay, I guess. Hey, Tanya. Thank you, Natasha. Exhibit 8-1, overflow room and live feed announced for the public. Now, this is May 29th. Now, this is going to get weird for me because I just saw an email dated May 25th that said there were not going to be a live feed or overflow room. So let's read this. The PIO, which is Steve, the public information officer, announced that the general public would watch a live feed of the jury selection process from the ceremonial courtroom, television monitors, audio provided, pen and paper notes permitted, and that once testimony began, the proceedings would continue following the same procedures. Do y'all see this? Anybody paying attention? Anybody see this? On May 25th, 2026, Steve told Nick at Night in an email that there will be no overflow room for the trial. On May 29th, 2026, 4 days later, I apologize, 4 days later, he announced publicly, the PIO announced that the general public would watch a live feed of the jury selection process from the ceremonial courtroom, television monitors, audio provided, pen and paper notes permitted, and that once testimony began, the proceedings would continue following the same procedures. Somebody lied. Why did Judge Roach snatch the overflow room, people? Why did he snatch it after jury selection? Why? What had happened? I'm curious. He wrote this. I guess this is the announcement. On Friday, May 29th. I guess this is the announcement. This is the Friday before the Monday that the trial started. Well, yeah. This is the Friday before the trial started, I think. Steve wrote, "Dear friends, for those of you who did not receive an approved media access to the Anthony trial, you will have an opportunity to access the proceedings with the general public on a first-come, first-served basis. Jury selection will begin at 9:00 a.m. Monday morning. The media and general public will have an opportunity to watch a live feed." Do y'all see this? He announced this through email Friday, May 29th. But keep in mind that on the 25th, he told Nick and Knight there was not going to be an overflow room. He knew there was not going to be an overflow room, even though he announced it to the public. Something weird is going on here. Jury selection will begin at 9:00 Monday morning, the media and the general public will have an opportunity to watch a live feed of the jury selection process from the ceremonial courtroom located on the first floor of the courthouse. Television monitors will be set up there. There's a fixed camera in the jury pool room. You won't see much, but you will be able to hear the proceedings with the audio that's provided. As you know, there is no recording available, and electronic devices are strictly prohibited. You will be allowed to bring in pen and paper to take notes. Since general public access is first come first serve, since general public access is first come first serve and space is limited, try to arrive as early as possible. The general public will enter the courtroom at 8:50 a.m. Once testimony begins on Thursday, the proceedings will take place in the 296th District Courtroom on the second floor of the courthouse, following the same procedures. Thank you for your cooperation, Steve. Why? Because he didn't want everybody to know the travesty, the corruption that was going on in this case, and not to have no one try to scrutinize the evidence to know the truth. Mm. Mm. I didn't realize reading these exhibits was going to take so long. How ignorant was I? Sergeant Davis conversation. This is Sergeant Davis conversation regarding admission of the media in the public cell phone video transcript and authenticating affidavit. Video exhibit. The cell phone video is filed conventionally on USB with a notice of conventional filing. The transcript and the authenticating affidavit of Tamitra Carter follow the sheet. Now, I don't know who Sergeant Davis is. Maybe he's from the Collin County Sheriff's Department. Tamitra Davis apparently had a phone call with him and she recorded it. And that was also submitted as evidence. So this is the conversation. This is the written conversation. The actual FaceTime recording was submitted as evidence. This is what was said. Sergeant Davis says, "Hi, I'm doing all right." Sergeant Davis, he said, "Hey, I'm doing all right." Sergeant Davis with Collin County Sheriff's Office. "Hey, is there a reason for you being here, right here?" Tamitra says, "I was waiting for because I'm going to read this how this is, y'all. I don't know. The language probably broken up or whatever. I don't know, but I'm going to read it how it's written." And Tamitra says, "I was waiting for because I know y'all gone, so I didn't know how y'all was gonna do it today. So I want to just follow however y'all gonna do it to get in the courthouse." Sergeant Davis says, "Okay, you will have to follow the same thing what we tell everybody else. You can park anywhere else, but you cannot sit. This is a construction in the." Maybe the recording was breaking up or something while the language is broken up, but apparently she recorded him on her phone or something. Tamitra says, "Okay." He said, "Because," and then Tamitra says, "So just go down there to that church." How? Sergeant Davis says, "It's, sir. You can go to the church. You can go. I mean, it's up to the church to call on." Tamitra says, "So are y'all letting media in like y'all did yesterday?" Sergeant Davis says, Media is allowed at 4:30 only, with their proof of media license." Tamitra says, "Yeah, because yesterday they had people that wasn't the media in there." Sergeant Davis said, "Trying to fix that." She says, "Thank you so much." Sergeant Davis said, "But it is really hard to." And then Tamitra says, "Determined. I was here at 4:30, and I'm the first person in line. And I go in, and it's already a 23. Yeah, we're trying to. Wow, 27 people in the public line. Yeah, so I'm not like, oh my God." That's what Tamitra says. Sergeant Davis said, "I understand, and it is really hard for us to determine who's what. And people print out whatever and make themselves like they are media, and it's hard for us to determine that." Tamitra said, "Right." Sergeant Davis said, "But I would recommend either the church there. There's also Life Path there." Tamitra says, "And then we come up at 5:36. You know what? Sergeant Davis said at six when they allow civilians to come in, non-media people. Okay, however, like I said, it's really hard. You can circle back and kind of keep driving up and down and see what's going on. But we are only allowing media at 4:30 because they come on at 5. Demetri said, Sergeant Davis said to do their live. Demetri says, whatever, because I just noticed like 27 people in the public line. Yes, and I was the first one in the gate. And I'm like, so how they right? So they must have come in as media. Sergeant Davis said, I'm assuming so. I don't know. I wasn't there. I wasn't here. Demetri says, but today y'all checking badges. He says they should be. Sergeant Davis said, I don't know. That is what we're told. We're supposed to check for media, and it's hard for us to even check badges. Sometimes they'll show us just cameras, and that's what we have to go with. I don't know. It's hard to determine. Demetri said, because if that's the case, I'm an independent journalist because I could. I report on my channel and stuff. Sergeant Davis says, yeah, that's including the Demetri says independent journalism. Sergeant Davis says right, like your TikTok and all that. No, that's not what we're allowing in. We're doing just media, not like Demetri says, because I seen a couple of them not saying that you're not important. That's not a couple of them in there that are independent and they got in first. Sergeant Davis said, yeah, I'm not sure how that's happening, but I know for sure we are trying to keep people out until 6 a.m., even media. We were trying to do that, but some of them have gotten approval. Demetri says, okay. Hi, Queen. Let me see what y'all saying. I'm trying to read this thing, so I'm not looking at the chat. Thank you. Y'all can support the channel. General admission and first come, first serve are the same. Yeah. Queen says, hey, Truth and everyone. I know you're on the time limit, but I'm in the bushes getting mad about a minute, but I want to share. What is it, Queen? What is it? Anyone can file an ethics complaint against this judge. His retirement doesn't stop an investigation or any penalties because he's under 65. His pension can be affected. Oh, wow. That answered your question right there, Cute. Thank you, Queen. She said, I'm filing. I'm talking about how do you do it? It's like you have to go to the where do you go to, Queen? Where do you go to file it? Excuse me, y'all. Keep it cute said thanks, Queen. Probably gonna have to do a part 2 on this one. Um hold on, y'all, let me drink some water. Oh, in person or by mail. You probably have to have a mail. Mm-hmm. Thank you for that information, Queen. I think everybody wanted that. Yep. Thank you for that. Um, I used to work for the Illinois Attorney Judge Disciplinary Board. Numbers of complaints matter. Oh wow. Oh wow. Um, I don't know how much more of this I can stand because with the broken English and stuff, I'm gonna skip through this, y'all. Y'all can go back and slow it down and read it. This broken English is killing me. She said, okay, so they got me lining up doing the same thing. So I'm gonna go up there maybe at 5:30. So basically, she had an issue with getting in. She was saying this Tamisha person was saying that she was trying to get in. Well, she was getting there early enough to get in, but basically, Tamisha's evidence goes towards that line breaking we was talking about. So y'all can go back and read that. Y'all can slow it down and read that. But that broken English is making my head hurt. But even with the broken English that's transcribed, she also submitted the audio. So the audio could be better. And this is her affidavit saying that what she submitted as far as the audio is authenticated. And that's her affidavit saying that. Kind of skip through y'all so we can hurry up. I want to get to Mike Jones, not Mike Jones. Oh, here it is. Ain't God good? This is Exhibit 10. This is affidavit of trial counsel Mike Howard, signed and notarized. Here we go, y'all. Pay attention. This is Mike Howard. For those who don't know, Mike Howard is the initial lawyer of Carmelo Anthony's in the initial trial, right? This is his affidavit. So we don't live in Texas, we can still file it. So I need to research to get it mailed to me. Right, Tanya. I know I am. All right, I'm gonna give y'all give me a second. Let me get me another water, and we're gonna start reading this affidavit. All right, here we go, y'all. Mm, you know what? Oh, thank you, Queen. Mm. State of Texas, County of Dallas. Before me, the undersigned notary republic on this day personally appeared Mike Howard, who who being by me duly sworn, disposed and stated as follows. I, Mike Howard, am at least 18 years of age and of sound mind, and I am competent and qualified to make this affidavit. I have personal knowledge of the facts that seated, I mean, I have personal knowledge of the facts stated herein and that are true and correct. I declare that I was the trial counsel, supported by second chair co-counsel Toby Shuk, third chair counsel co-counsel Tasha Gupta, and briefing appellate co-counsel Michael Mauler, who represented Carmelo Anthony in cause number blah 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 blah. Leading up to the June 1st, 2026 trial of this case, the defense and prosecution reached an agreement where the prosecution, this is very important, y'all. This is where he talks about that agreement that was not placed on the record. You know, the one that was breached. You know, that one, the one that caused Carmelo not to testify. This is what he's talking about. Hey, Melissa. He says, leading up to the June 1st, 2026 trial of this case, the defense and prosecution reached an agreement where the prosecution and defense jointly agreed to not raise any alleged character, reputation, or extraneous offenses, bad acts, evidence relating to Mr. Anthony as well as Austin Metcalf and Hunter Metcalf during the trial, here and after referred to as the agreement. Okay. The lead prosecutor in this case, Bill Werski, brought up the possibility of the agreement a number of times well before the agreement was discussed in detail and eventually reached. When mentioning a proposed agreement, Mr. Werski proposed that we try the case clean, which he defined as based only on what happened under the tent that day, under the Memorial High School tent at Q Kendall Stadium on April 2nd, 2025, and not go into character, reputation, or extraneous offense and or bad acts evidence applicable to either Austin and Hunter Metcalf or Carmelo Anthony. On May 5th, 2026, Mr. Shuk and Mr. Werski discussed. Now he's saying right here on May 5th, Mr. Shuk is co-counsel. Mr. Shuk, who is Carmelo's co-counsel, and Mr. Werski, who is the prosecutor, discussed an agreement on the phone. Not Mike Howard, who was his lead attorney, but Mr. Shuk, who is friends with Mr. Werski and friends with Roach. They had a phone conversation. On May 5th, 2026, Mr. Shuk and Mr. Werski discussed this proposed agreement by phone. During that phone call, Mr. Shuk and Mr. Werski discussed the evidence of character, reputation, and extraneous offense, bad conduct, as it applied to both the Metcalf twins and Carmelo Anthony. Toby Shuk and the prosecution in the case were friends and they used to. Yeah. Mr. Werski reiterated that he would be happy to try this without getting into character at all, just on what happened the day of the track meet. On May 8th, 2026, hold on. So that phone call took place on May 5th. 3 days later, on May 8th, 2026, the defense and the prosecution teams met in the Collin County Grand Jury Room. The prosecution team gave us a document entitled State's Notice of Intent to Use Extraneous Offenses. And we gave to them a document entitled Anthony's Motion in Limine regarding the admissibility of pertinent character trait evidence under the ambiguous aggressor rule. I'm not going to read all that. So after tendering to each other our respective extraneous filings briefings, we then discussed. So basically on this day on May 8th, each side presented to each other what they were going to use against the other side. The state presented to the defense what they were going to use against Carmelo, and Carmelo's attorneys presented to the state what they were going to use against the Hunter boys. After tendering to each other our respective extraneous filings briefings, we then discussed the proposed agreement, which Mr. Werski, who is the prosecutor, referred to as a gentleman's agreement. Mr. Werski outlined the proposed agreement as follows. Both sides tried the case without character, reputation, or extraneous evidence for either the Metcalf twins or Carmelo Anthony, and just tried the case based on what happened up under the tent. and doing another description during that meeting what happened on the day of the incident. Seeking clarification, I asked, and Mr. Worski confirmed that this would mean that the defense would not go into evidence relating to the Metcalf twins' character, reputation, and extraneous offenses, bad acts related to violence and bullying, inclusive of discipline and write-ups in the Metcalf twins' school records within this framework. So apparently, the Metcalf boys has write-ups in school records. They got discipline and write-ups in school records. The Metcalf boys does, right? As well as racism. In exchange, the prosecution would not go into character, reputation, and extraneous offenses evidence relating to Carmelo Anthony, inclusive of the contents of Carmelo Anthony's cell phone and school disciplinary records. At this meeting, I sought clarification on how this agreement would work practically, specifically how to handle the possibility of opening a door to this evidence from either side. During this meeting, Mr. Worski repeatedly expressed his concern that the defense would kick open its own door by asking questions of witnesses that would divulge into issues restricted by the agreement. I asked about specific statements made by witnesses, interviewed by police, and captured by video. Wait a minute. Are y'all hearing this? There's video. There's video, y'all. I'm going to read that again. I asked about specific statements made by witnesses, interviewed by police, and captured by video. And captured. Ooh, boy, I think I need a drink. Is it Friday? Is it noon yet? Oh, baby. This was to keep from allowing their true character to be known and that Carmelo was possibly being bullied before he acted. Absolutely, Sonia. Absolutely. And there's video, people. How many times have we... Let me read that and I'm keep going. Whew. I asked about specific statements made by witnesses interviewed by police and captured by video on the day of the incident, where those witnesses discussed the Metcalf twins being passionate, triggered, and not tolerating being disrespected. Mr. Worski eventually agreed that questions narrowly tailored to ask about specific statements the witnesses made to police about the incident under the tent on April 2nd, 2025, including statements just described about the mindset and actions of the parties involved in the incident. Thank you, Tony. Would not constitute kicking open your own door and thus would not violate our proposed agreement. During this meeting, we discussed the terms of the agreement being that testimony from eyewitnesses from under the memorial tent on April 2nd, 2025, and who were discussing the facts of what happened under the memorial tent on April 2nd, 2025 would be permissible, and that neither side would go into character, reputation, or extraneous evidence for either the Metcalf twins or Carmelo Anthony. During this meeting, I also asked about the agreement regarding the possibility of the defense calling experts. The prosecutors only discussed how the agreement would apply to defense experts during the sentencing phase. So I asked how the possibility of the defense calling expert witnesses to testify during the guilt innocence phase would impact the proposed agreement. The prosecutor team replied that they had not considered us calling experts to testify during the guilt innocence phase. They stated that if the defense called experts to testify regarding Mr. Anthony's epilepsy or about a fight or flight response, they consider expert testimony like that to violate the agreement and thus open the door to So basically what the state told the defense is, if you call an expert to talk about Carmelo's epilepsy and his fight or flight response, you're violating this agreement. They told Mike Howard, if you call your experts to defend this young man, a viable defense, you would be violating this agreement. And I said yesterday, and I fucking stand on it, they should have never made that agreement. I don't know what Mike Howard was, what mindset he was back then. I see now he's trying to be whatever he's trying to do. But back then, he should have never entered into that agreement, ever. These boys had a record. They had prior offenses. They had a reputation. They had a reputation with Carmelo would have automatically, we don't know why the young man was so scared, but he knows why he was so scared. He knew them as bullies. He knew their reputation. Everybody knew their reputation. This young man couldn't even defend himself because his idiotic attorney entered into a stupid ass agreement. They stated that if the defense called experts to testify regarding Mr. Anthony's epilepsy or about a fight or flight response, they considered expert testimony like that to violate the agreement and thus open the door to character, reputation, and extraneous offense acts evidence. On May 11, 2026, Mr. Worski, Dewey Mitchell, Mr. Shook, and I discussed the proposed agreement again by phone. I informed the prosecution that we had an informal agreement on the proposed agreement, but that we needed to have a final conversation with Mr. Anthony and his parents to confirm the final agreement. During this phone conversation, Mr. Worski confirmed that the agreement would extend to the sentencing phase of the trial as well. Mr. Worski said that would mean that, in accordance with the agreement, the prosecution would quickly rest its sentencing case in chief without going into any of the allegations listed in the state's notice. Mr. Worski said, however, that we would not allow a false impression to be presented to the jury by a defense witness, and that if such a thing occurred, he would respond by going into character, reputation, and extraneous evidence from the state's notice. After the defense asked about an Anthony family member testifying at sentencing, Mr. Worski agreed that the agreement would cover Mr. Anthony's mother testifying to the standard, "I love my son. Please show him mercy" type testimony, but no further. So basically, they told that woman what to say on the stand. You could never. It wouldn't have happened. You could never have told me what to say when I'm on the stand and my son is facing life in prison. You couldn't tell me just to get up there and say, I love my son. Show him some mercy. What? What? This woman got up on the stand and recited what the white people told her to say. How the fuck do you do that? How do your mental allow you to do that? Them parents need to take their asses back to Louisiana South, those neighborhoods, being around so-called gray areas, which is their neighborhoods is not always good for our kids. He said, wow, they told her to say that. Carmelo and his family were railroaded. I would have never went along with none of this BS. His ass would have been fired. She trusts them folks. It's crazy. It couldn't have been me. On May 21st, 2026, the defense and the prosecution teams met with Judge Roach in his chambers. During that meeting, both sides explained the agreement to the judge. I thought he didn't know anything about the agreement. Didn't I read earlier what Judge Roach said he didn't know anything about this agreement, y'all? Am I tripping? Because this is why I take the time, whether people are listening or not, and I read this stuff. Didn't I read earlier in this motion that Judge Roach said he didn't know anything about this so-called agreement? Or am I tripping? Sometimes I dream, and I get my dreams mixed up with reality. So y'all let me know that y'all hear me say that. Did y'all hear me read that Judge Roach say he didn't know anything about the agreement and that he couldn't enforce the agreement? I know I read that, whether I was dreaming or in real life. I know I read that this man said he did not know anything about an agreement and he couldn't enforce it. Okay, great. Thank you. I'm not tripping. Okay, great. So, on May 21st, 2026, now this is before the trial. Mind you, the trial didn't start June 1st. On May 21st, 2026, the defense and the prosecution teams met with Judge Roach in his chambers. During that meeting, both sides explained the agreement to the judge, describing it again as both sides agreeing not to go into character, reputation, or extraneous evidence as it applies to both sides during both guilt, innocence, and sentencing phases. As long as no doors are open or false impressions given, we agreed that the best way to document such an agreement would be for the defense to draft and file a motion in limine applying to character, reputation, and extraneous evidence applicable to all witnesses. So it would cover both the Metcalf twins and Anthony, but if made public, would not trigger reporting in the media about bad evidence specific to certain witnesses, thus endangering a fair trial. So basically, that's saying they drafted up the agreement, but they kept it hidden so the media couldn't get to it. On May 21st, 2026, I drafted the motion in layman as described above and sent it to Mr. Worski by email. It was hand-delivered to the judge on the opening day of the trial. Now, why wasn't it sent to the judge by email? See, that's a paper trail. See, sending it through email, that's a paper trail. But it was hand-delivered to Judge Roach. So Judge Roach can later come out and say, I don't know nothing about no meeting. Why was it sent? Who hands delivers mail? Who hands delivers things anyway in 2026? This was strategic. This was strategically done, people. So Mr. Worski, he received the agreement through email. But Judge Roach got his copy hand delivered. So there would be no paper trail. So he can later say, I knew nothing of this agreement. Y'all get me? Okay, let's go. The defense understanding of the agreement. The defense understood the agreement with the prosecution to cover all witnesses who could be called to testify by either the prosecution or defense about the incident that occurred between Mr. Anthony and the Metcalf twins and their teammates under the memorial tent on April 2nd, 2025. As every description of Mr. Worski described the agreement to allow for testimony about what happened under the tent. And Mr. Anthony was obviously a witness to what happened under the tent by the plain meaning of the language Mr. Worski repeatedly used. The defense always understood the agreement to cover Mr. Anthony's potential testimony just as it would any other witness to the incident under the tent on April 2nd, 2025. Following the plain meaning of Mr. Worski's words in describing the agreement, the defense understood the agreement to cover testimony about eyewitnesses such as the memorial students underneath the tent at the time of the incident, Hunter Metcalf, students outside the memorial tent who looked over and witnessed the incident, and Carmelo Anthony. This understanding of the agreement was further confirmed by events that occurred after the motion in layman memorializing the agreement was drafted and tendered to the prosecution. On May 29, 2026, after a meeting with Judge Roach and the prosecution, and the defense to discuss how trial security would be handled, the parties discussed the timing of the state's case in chief and when the defense case in chief will start. Mr. Worski informed the court and defense that he estimated it would take 3 days for the state to present its case in chief, which would have ended sometime on Saturday, June 6, 2026. In response, this is Mike Howard talking, I voiced concern to the judge in front of the prosecution team that some of the witnesses the defense anticipated calling to testify were unavailable on Saturday, June 6th. I explained that, like in any case, I would not know until the final moment whether we would call our client for sure, but that if the prosecution rested sometime Saturday and the judge forced us to call witnesses immediately on Saturday, I may not have enough witnesses available to fill up a full day of testimony Saturday. I explained that if this happened, it will force me to call my client out of order. The defense plan was to call all our fact witnesses first to establish certain facts and then conclude by calling our client to testify as our last witness. On Friday, June 5th, 2026, the second day of testimony during the state's case in chief, I checked in with Mr. Worski about how he was proceeding and whether he would end up taking more or less time to present his case in chief than he had initially estimated. Mr. Worski informed me that he was moving more quickly than he had initially estimated, so the prosecution was on track to rest its case in chief midday Saturday. In this conversation with Mr. Worski, I again brought up the fact that several defense witnesses were unavailable on Saturday, and if the judge proceeded with his plan to force the defense to call witnesses immediately upon the prosecution resting in order to have a full day of testimony on Saturday, we might be forced to call our client out of order. Not the ancestors. Y'all, listen. All right. This time, I did not preface this statement with the like in any case. I won't know if I'm going to call my client at the last minute because I was not on the record and was speaking frankly with opposing counsel. I was very plain about the defense's intention to call Mr. Anthony to testify and how the judge's proposed schedule requirements were going to force us to call Mr. Anthony out of order. I don't independently recall what time on Friday, June 5th, this conversation with Mr. Worski occurred, but it must have occurred just before noon because I then sent an email to Michael Mauler describing the problem we were facing and asking Mr. Mahler to draft a brief for us to argue to the judge that he couldn't force us to call our client out of order. Throughout the morning and early afternoon of Saturday, June 6th, Mr. Shook, who is co-counsel for Carmelo, and I repeatedly checked in with Mr. Worski to get updated estimates of when he might rest his case in chief, each time referring to how the judge's plan was going to force us to call our client out of order. Hey, L Boogie, much love, boo. We got some mad folks in here, L Boogie. Your sisters are mad, honey. They is upset, and willfully so. Yes. Funberry want to sue the ancestors. Dig them up. Bring them to court too. Bring them up. Damn. Besides the defense team repeatedly mentioned in front of Mr. Worski and the rest of the prosecution team that we intended to call our client to testify, even if it meant it would be out of order, Mr. Worski's own actions and arguments made it clear that he knew full well that we intended to call Mr. Anthony to testify. Even before both sides tendered their notices of and arguments in favor of the admissibility of character, reputation, and extraneous evidence pertaining to the other side's witnesses, Mr. Worski made reference to understanding that the defense sought to introduce character and reputation evidence about Austin and Hunter Metcalf that was uncommunicated, unknown to Mr. Anthony via the ambiguous aggressor rule. The ambiguous aggressor rule and the admissibility of uncommunicated character and reputation evidence of the decedent in a murder case are all part of a self-defense argument. Absolutely. Torres discusses in depth how the ambiguous aggressor rule allows the defense to put on uncommunicated character and reputation evidence before or after the defendant testifies. Mr. Worski repeatedly brought up Torres in discussions with the defense team in the months leading up to the trial, stating that while he thought the judge would rule correctly and not allow the evidence, he conceded that character evidence could be allowed. This repeated discussion of Torres and how it may apply to the trial showed that Mr. Worski was well aware of at least the possibility of Mr. Anthony testifying in order to argue self-defense. This was the entire purpose of the agreement, and that it provided value to the prosecution. Ain't that what I said, y'all? I hope y'all been listening. I hope I ain't been reading all this stuff in vain, because this right here is a hot mess, and it makes so much sense. Didn't I say, did anybody hear me when I said that this agreement that was made and agreed to was only to benefit the state? Only to benefit the state. And right here in this motion, Mike Howard is saying the same thing. Yet he didn't notice that back then when they agreed to it. He didn't notice back then that that agreement that he made and entered into was only to benefit the state. He didn't know that. I knew it, and I'm not a lawyer. I knew it, and I don't know everything he knows. And now a year later, 35 years that this young man has been sentenced to later, he's realizing that agreement only benefited the state. How did you not know that in the beginning? How? This was the entire purpose of the agreement, in that it provided value to the prosecution, limiting the defense from presenting damaging character and reputation evidence against Austin and Hunter Metcalf. And the defense, from the defense's perspective, the entire agreement centered around the defendant testifying without impeachment by character, reputation, and extraneous evidence in exchange for the defense not seeking to introduce character, reputation. They keep saying the same fucking words. It irritates me. Against the Metcalf twins. Furthermore, any competent criminal trial lawyer knows that for a self-defense argument to have any chance of succeeding, the defendant must testify. For all these reasons, the defense always understood the agreement to include Mr. Anthony's testimony free of impeachment by character, reputation, and extraneous offense, bad evidence, just like every other witness either side could call to testify about what happened under the tent. So basically what Mr. Howard is saying right here is that the prosecution knew that he was going to call his client. He knew there was a possibility that he was going to call his client. Because just like they knew, and just like we as the Lane public knew, that in order for Carmelo to beat this case, he would have to testify. So Mike Howard is saying he thought, as far as the agreement was concerned, was that he was not to let other witnesses testify as to bad acts. But Carmelo was to get up there and tell his truth. But as we know now, the state put a halt to that. They put a halt to that. We talked about it, what they did, well, what they said. And it's going to be in this. We're going to read some more. Before we do, though, we're going to the next segment. Hold on. The next section is the defense's reliance on the agreement. I'm going to take like 5 minutes, y'all. Can I have 5 minutes? I'm going to go to the restroom. I'm going to get me another water. I'm going to digress for a minute, and then we're going to come back. How long I've been reading? 3 hours. Okay. We have to do more research on how many other cases have they thrown and disrupted internets like this. Yeah, that's going to take a lot. That's a lot. Okay. All right. Y'all give me five. Y'all abuse about to fire Toby ass. I thought Mike Howard was his attorney. It could be Toby too, because Toby is co-counsel. But I thought Mike Howard was. So Mike Howard's not Breeze's lawyer. Is Toby. I'll fire their asses. They wouldn't be defending me. I don't give a damn. But anywho, y'all, I'm gonna take. It might not even be 5 minutes. I'll be back in about 5 minutes. Maz, hold the chat down for me, please. And when I come back, we'll finish this. Okay? Give me about 5 minutes. back, y'all. Y'all ready? Y'all ready to get back started? Lord have mercy. I think reading this stuff is more exhausting than just doing regular content. That's crazy, but hey, it is what it is. Um, all cases with their name needs to be thrown out. Well, actually, if they find corruption, that's gonna have to happen. Sad to say. If they find corruption, all of their cases gonna be scrutinized. Yep. Keep it cute, basically. Welcome back, Miss Lynn. Welcome back. Is Marilyn here? Hey, birthday girl. Birthday girl, birthday girl. Where's she at? Um, I don't see her. Maybe it's in God's time because I'm convinced the jury was tainted. Oh wow, okay. Keep it cute. Yes, it was said to happen. I told y'all it was a purpose behind all this. Oh, you said leaving your doctor's appointment. Especially that judge. Yeah, that judge is off the chain. Hmm. Y'all keep talking. I'll be right back. All right, y'all. Yes, thank y'all for the likes. Y'all continue to hit that like button for your girl, please, and thank you. I appreciate it. We're gonna get back to this reading. Of course, my other live stream is late, but that's okay. We'll get to it. We will get to it. What this is? Oh, okay. Um, sorry, y'all. I was reading something. I'm sorry. Yes, them. All right. Number 13, the defense's reliance on the agreement. Throughout the trial, the defense revised its trial strategy and reliance upon the agreement. Absent the agreement, the defense intended to cross examine each memorial student witness. This is what the defense planned on doing before this agreement was put in place, which I think, to be honest, with Shook being in the state's pocket, and what I mean by that is, absolutely, if not Mike Howard and Shook, absolutely Shook was probably communicating with the state, Mr. Worski, and letting him know what their strategy was, because let's be clear, they were friends, right? So Mike Howard is saying, throughout the trial, the defense revised its trial strategy in reliance upon the agreement. Absent the agreement, which means before the agreement was made, the defense intended to cross-examine each memorial student witness the prosecution called about Austin and Hunter Metcalf's character and reputation for violence, for being bullies, and for racism. The defense also intended to cross-examine these witnesses about various statements they had made to the police on April 2nd, 2025, regarding Austin and Hunter Metcalf being easily triggered and having a loud mouth, being passionate, not allowing themselves to be disrespected. Some specific examples include Austin's a really big. Now these are statements that the students made to the cops on the day of this incident, right? These are statements that some of the students made. Austin's a really big guy, and he's kind of like the aggressive guy on the team. Austin got the same way. Austin got the same way that he got during the altercation. It's the same way he got with some of us. And the mellow kid, something or whatever, and then Austin kind of got triggered. Now, these are quotes, right? So these are quotes. So this is coming from these kids, and they are written down verbatim. So I'm gonna read them like it's written. Austin is a really big guy, and he is kind of like the aggressive guy on the team. Austin got the same way that he got during the altercation is the same way he got with some of us. And the mellow kid did something. The mellow kid something or whatever, and then Austin kind of got triggered. Austin and Hunter, they're not going to let you disrespect them. And Austin, he's like a big guy, so nobody really wants to fight him. And Austin's really a passionate guy. And Jose told police about Austin's history of fighting and almost getting kicked off the football team for fighting. Jose told police. Now, Jose is one of the students that testified on the stand. And Jose initially told the police about Austin's history of fighting and almost getting kicked off the football team for fighting. I've known Austin for a while, and if Austin is about to get into a fight, you can tell. Austin can be a bit aggressive at times, and he has a bolder mouth sometimes. If the prosecution did not call any of these witnesses, the defense was ready to call them during the defense's case in chief and question them as hostile witnesses. Therefore, furthermore, the defense intended to call witnesses familiar with Austin and Hunter Metcalf's reputation for violence and bullying. The defense intended to call witnesses who themselves were victims of the Metcalf twins, violence, and bullying. The defense intended to question Memorial High School teachers about the Metcalf twins' disciplinary history contained in their school records, which corroborated their character for violence and bullying. And finally, the defense intended to elicit testimony about the Metcalf twins' arrest for racist graffiti. I still ain't seen that, but it's mentioned. That's where that content creator must have got it from. This motion right here. Racist graffiti. Wow. Anyway, I wish I had known what they wrote. Like I'm curious as to what they wrote in that racist graffiti. Hmm. In good faith reliance upon the agreement, the defense did none of this. The defense even limited its questioning of witnesses about statements they had made about the Metcalf twins being triggered, having a loud mouth, and being passionate, etc. That had been deemed to be allowed under the agreement. That had been deemed to be allowed under the agreement in an abundance of caution to avoid opening the door. Furthermore, because the prosecution had made it very clear that the defense calling any psychology related expert would open the door to character, reputation, and extraneous evidence pertaining to Carmelo, the defense chose not to designate any experts and ultimately chose not to call as a witness a neuropsychologist to discuss how Mr. Anthony's epilepsy impacted his perception of threat and response, as that is relevant to self-defense, and a forensic psychologist to discuss both brain development of a 17-year-old as well as the fight or flight response as it applied to Mr. Anthony's actions. As a result of the revision in defense strategy, the defense did not go into these subjects during jury selection or opening statement. Without such an agreement, or if the defense had suspected that the state would violate the agreement, the defense would have explored these subjects during jury selection and would have introduced these topics during its opening statement. In sentencing, in reliance upon the agreement, the defense did not designate an expert who was ready to testify regarding mitigation, i.e., a risk assessment and psychological profile of Mr. Anthony. Furthermore, in reliance upon the agreement, the defense severely limited its available character witnesses to just 3 questions of Mr. Anthony's mother, which had been previously agreed upon by the prosecution. Other than general character testimony and pleas for mercy in reliance upon the agreement, the defense also did not go into substantial family violence Mr. Anthony had witnessed and had been a victim of in his home. What? Wait a minute. Other than general character testimony and pleas for mercy and reliance upon the agreement, the defense also did not go into substantial family violence Mr. Anthony had witnessed and had been a victim of. Who in the hell? So is the daddy? Wait a minute. I ain't gonna assume. I'm not gonna assume. But this is their motion. And this motion is saying that Mr. Anthony has been a witness to and a victim of domestic violence. What? Oh, wow. Oh wow. No, Tanya. No. No, no, no. No, no, no. We're not talking about the Metcalves. We're not talking about the Metcalves. We're talking about the Anthonys. We're not talking. You misunderstanding what I'm reading. We're not talking about the Metcalves. We're talking about the Anthonys right now. Mm-mm. According to this motion, there was domestic violence in the Anthony home, not the Metcalves. Now, let me say this. I think, if I'm not mistaken, I don't think, and y'all let me know if I'm trying to figure out how I think, because I think they have. Hold on, let me check something out right quick, and I'm gonna tell y'all what I think. Hold on, let me Google something right quick. Okay, so I remember that I possibly was so happy. Sonya, what are you talking? What are you talking about, Sonya? I be kidding. Sonya, you be confusing me sometimes. I know you noticed that. Like, I be confused. Like when you make a statement, I be confused, and I be wanting to understand what you mean. So listen, what I looked up is this. I remember that I got that last name and the Metcalf son's first name mixed up sometimes. We're not talking about the Metcalves, y'all. Good gracious. We're not talking about the Metcalves right now. We're talking about the Anthonys, right? So listen, I remember when the parents had came out or whatever, that there was some different last names somewhere, but I couldn't remember where the last names were different, right? So Kayla, who's the mom, her name is Hayes. Kayla's name is Hayes, her last name, and then Drew, who is the dad, his last name is Anthony, right? So what I was thinking was this. Now I don't know. I don't know, y'all. I did research. I don't see any evidence of the father being in a domestic violence case. See what I'm thinking, Lanier, and I don't want to assume. I don't want to make assumptions, and I don't want to put a narration out there, right? But see, it is all possible. Now, this man didn't go into depth, right? So it is all possible that there could have been some domestic violence. But what I was thinking was that maybe that Carmelo wasn't Drew's biological child, and that maybe Kayla had been with somebody else before Drew. Because I just don't see that dude. And we don't know people, and monsters come in all shapes, colors, forms, of fashion. But I just don't see that dude being a woman beater. And I'm thinking that maybe he saw it, but it wasn't between, per se, his dad and his mom. Like maybe it was between somebody else. You know what I'm saying? Anthony May had been exposed to DV, but I'm saying so had Austin. I was trying to figure out why that information was used. I hope. Um, I'm just gonna read what's on this paper. I ain't gonna even try to figure it out. According to Anthony's Carmelo's attorneys, he witnessed and was a victim of DV. That's all I know. That's all I know. So I'm gonna read that again. Other than general character testimony and pleas for mercy and reliance to the agreement, the defense also did not go into substantial family violence, Mr. Anthony. And it doesn't even say like, okay, it says family violence Mr. Anthony had witnessed and been a victim of in his home. That's all it says. And I'm gonna leave it right there because I can't. I can't. On Saturday, June 6, 2026, after the prosecution rested its case in chief, the defense called witnesses Adam Linwood, Jeremiah Smith, and Jose Andres Ramos Mora before end of the day in the late afternoon, early evening. Um, or the prosecution called those witnesses. On Monday, June 8th, the defense resumed its case in chief, calling Brendan Stevens and Brennan Lacey. The defense's next planned witness had been avoiding, and they whited out that name for some reason. I don't know. The defense's next planned witness had been avoiding the defense's subpoena and kept changing the time he told us he would arrive at the courthouse. Accordingly, after Mr. Lacey's testimony, we took a break at 10:50 a.m. to see if such and such had arrived. Now, for some reason, they left that person's name out, whoever that was. Tanya, they're talking about Carmelo in this motion, and I'm talking about his daddy. They saying that I'm gonna make it plain. I'm gonna make it so plain. I'm gonna move on. This motion is saying that Carmelo Anthony has witnessed and been a victim of substantial You know what? I'm just gonna read the statement one more time. The defense also did not go into substantial family violence Mr. Anthony, aka Carmelo, had witnessed and been a victim of in his home. Yep. He has been a victim of and has witnessed substantial family violence in his home. His home. During the 10:50 a.m. break in the back hallway outside the judge's chambers, the judge asked us for an update about timing, how many more witnesses, etc. I explained that the next witness the defense had planned to call was a Centennial High School coach. So that's whose name they blacking out, y'all. Is a coach from the high school. He dodging the subpoena and shit of that nature. Mr. Worski asked what the coach would testify to that did not pertain to Mr. Anthony's character. Okay, well, that doesn't mean he would intentionally cause violence. I don't think they was going to introduce that into evidence as to say he was violent. I think they would have introduced that into evidence to say that being as though he's witnessed violence and he has been a victim of violence, he was at a heightened level, which means if you are a kid that is getting beat on, or you are always in a state of heightened wanting to protect yourself and not get beat on, then if somebody is threatening or pushing on you and about to jump on you, that can heighten your sense of fight or flight. Because I don't think they would have introduced that into evidence saying, oh, he was violent because he had experienced violence. His team wouldn't do that. That would be against him. The only thing I can see them introducing that into evidence is to say, look, this kid has witnessed violence. He has been a victim of violence, which heightened his sensitivity to violence. Get me? Could have triggered him. Right, Tanya? Could have been a trigger. Could have been a trigger. That's why you don't fuck with people. Because you don't know. That's why you don't, you know what I'm saying? Not physically anyway. Fuck words. Words ain't words, words are words. You know what I'm saying? But once you step that and cross that line and go to put your hands on people, that's something different. I'm like that. You trigger me. If you get all up in my space, close enough to me to put your hands on me and you aggressive, that's a trigger. I'm gonna get you up off me. By any means necessary. Because I'm not gonna let you hurt me. People that have been victims of violence, they have triggers. They have triggers. Motherfuckers who've been standing in front of a motherfucker just having a conversation and all of a sudden out the blue get hit in the face. You get triggered. You can't get that close to me. You can't get close to me to put your hands on me. Not in an aggressive sense. You can't do that. I'm gonna get you up off me. That's what that is. Yep. That's what it is, y'all. During the 10:50 excuse me, y'all. During the 10:50 a.m. break in the back hallway outside of the judge's chambers, the judge asked us for an update about timing, how many more witnesses, etc. I explained that the next witness the defense had planned to call was a Centennial High School coach, Mr. Worski. Asked what the coach would testify to that did not pertain to Mr. Anthony's character. I explained that his coach had witnessed Mr. Anthony's seizures. Oh, wow. So he would testify about Mr. Anthony's epilepsy based on his personal knowledge. Mr. Worski then argued that testimony about epilepsy was irrelevant at guilt, innocence, and to the extent it was relevant, would open the door to character, reputation, and extraneous evidence against Mr. Anthony. In plain terms, it would breach the agreement. If they called somebody or anybody that would speak on this young man's epilepsy, that was breaching the agreement, right? I stated that I disagreed, explaining how it was relevant to Mr. Anthony's state of mind pertaining to self-defense, and that it did not relate to character, reputation, or extraneous evidence in any way. But Judge Roach agreed with Mr. Worski that he thought testimony about epilepsy was not relevant during guilt, innocence, and would open the door to character, reputation, and extraneous evidence. That's a lie. That's a lie. Based on this, I informed the court that I would not call the coach and that I anticipated having one or two more witnesses before I would call Mr. Anthony. In response to the judge's question about likelihood of Mr. Anthony testifying, I told the judge that we would need to confer with Mr. Anthony about his Fifth Amendment decision regarding testifying, but that I was 99% sure that he would in fact testify. After the break, back in court before the jury to give whoever more time to arrive at court, we then called Frisco Police Department Detective Riley to testify. After Detective Riley finished testifying, I then decided to call such and such as a witness, and we broke for lunch early around 11:17 a.m., and the prosecution and defense team stayed behind to talk to the judge outside the jury's presence. On the way back to chambers, Mr. Worski mentioned to Mr. Shook that from his perspective, I had already opened the door to character, reputation, and extraneous evidence pertaining to Mr. Anthony by saying that Mr. Anthony was a member of the chess club during my opening statement. Listen, y'all, this is where it gets grimy. This is where it gets grimy. On the way back to the chambers, Mr. Worski, who is the state prosecutor, mentioned to Mr. Shook, who is Carmelo Anthony's co-counsel, that from his perspective, I had already opened the door to character, reputation, and extraneous evidence pertaining to Mr. Anthony by saying that Mr. Anthony was a member of the chess club during my opening statement. I did not say anything about a chess club at any time during my opening. I said that Mr. Anthony played chess during my background description of him and his hobbies. Wow. So Mr. Worski lied. Mr. Worski said the reason why the defense had breached the agreement is because they said that Carmelo was a member of the chess club. But Mr. Howard is saying he didn't say that. He said that Mr. Anthony played chess during my background description of him and his hobbies. They played dirty. Period. They played dirty. Mr. Worski also stated that from his perspective, the agreement did not cover a testifying defendant. Mr. Shook alerted me, and Mr. Worski, Mr. Mitchell, Mr. Shook, and I stood in the well of the courtroom, and Mr. Worski repeated these statements, adding that the prosecution never thought that the defense would call Mr. Anthony to testify. That is bullshit. That is bullshit. Hey, Renee, girl. Because hey, Patricia, any and everybody knows that if a person is on trial for murder and they don't have a criminal background, no. I'm going to put it like this. Most likely, if a person is on trial for murder and they plead self-defense, whenever anybody pleads self-defense, it is always in their best interest to get up on the stand and state why they felt threatened. Period. The prosecutors, now, mind you, in this whole motion or in this whole statement, Mr. Howard is saying the prosecutors knew I was going to call my witness. In fact, they may not have known for a fact that I was going to call him, but they knew it was a possibility. And he's stating that when he talked to Mr. Worski earlier on Saturday, he told him that it was a 99% chance that he was going to call Carmelo to that stand. And this is how they chose to stop it. They did not want Carmelo on that stand. They knew Carmelo getting on that stand, stating how he felt at the time, what his mindset was, what he thought, that was going to get him off, y'all. They knew that. And that's why they had to stop him from hitting that stand. And that's why this Mr. Worski came up with rejecting that agreement. Mr. Worski also stated that from his perspective, the agreement did not cover a testifying defendant. Mr. Shook alerted me, and Mr. Worski, Mr. Mitchell, Mr. Shook, and I stood in the well of the courtroom, and Mr. Worski repeated these statements, adding that the prosecution never thought that the defense would call Mr. Anthony to testify. Back in the judge's chambers, um, Back in the judge's chambers, Mr. Worski repeated his assertion that the agreement between the prosecution and defense never contemplated a testifying defendant. He elaborated, stating that he had never thought we were calling Mr. Anthony as a witness. He also repeated his claim that I had already violated the agreement during my opening statement by saying that Mr. Anthony was a member of the chess club. It is important to note that this was the first time Mr. Worski mentioned that he believed I had violated the agreement days earlier by mentioning that Mr. Anthony played chess during my opening statement. Although the prosecution and defense teams had confirmed many times throughout the prosecution's case in chief about various issues, this was the first time Mr. Worski brought up this assertion. Judge Roach told both the prosecution and defense teams that my mention in chess during the opening statement definitely did not open the door to character, reputation, and extraneous evidence applicable to Mr. Anthony. So the judge agreed that what the state was saying was a lie. They agreed that the defense did not open the door. So let's see what happens. Let's see why Anthony didn't take that stand. Judge Rose told both the prosecution and defense teams that my mention in chess during the opening statement definitely did not open the door to character, reputation, and extraneous evidence applicable to Mr. Anthony. The parties argue about whether the agreement between the parties covered Mr. Anthony's testifying. The prosecution repeated their position that it did not, and that if we call Mr. Anthony to testify, character, reputation, and extraneous evidence pertaining to Mr. Anthony were in play. Furthermore, Mr. Worski stated that Mr. Worski stated at that time. Furthermore, I'm getting fucked up. Furthermore, Mr. Worski stated at that time that the prosecution already having rested character, reputation, and extraneous evidence pertaining to Austin and Hunter Metcalf was not relevant. Mr. Shook and I mentioned the ambiguous aggressor rule from Torres. Mr. Worski agreed that Torres did not apply because it was not ambiguous who the first aggressor was, that the first aggressor was clearly Austin Metcalf. At this point, the discussion devolved into a shouting match. So they was arguing. They were going blow to blow. They were arguing about this agreement, y'all. I wish I could have been a motherfucking gnat, not even a fly, bitch. Make me a gnat. I wish I had been a gnat on the wall, a fruit fly on the wall when this was going on. They got into a whole shouting match because that prosecutor was full of shit. Impact on the defense case. After the breakdown of the agreement, the defense and prosecution teams agreed to take 10 minutes to cool off before attempting to renegotiate parameters for how the agreement could extend to Mr. Anthony's testimony, should the defense now choose to call him. After the 10-minute cooling off period, Mr. Worski and I met in open court, outside the presence of the jury and without the public in the room, to discuss possible parameters for the agreement covering Mr. Anthony's testimony. Given Mr. Worski's expansive view of what he considered would open the door to character, reputation, and extraneous evidence pertaining to Mr. Anthony, especially his repeated claim, even after the judge stated otherwise, that even my mention of playing chess opened the door to character, I resolved that my only choice was to go over my planned outline of Mr. Anthony's direct examination line by line with Mr. Worski to determine what would and what would not, in Mr. Worski's view, open the door. I have never taken such a drastic step of previewing my strategy and even my questions with the prosecutor. But as a defense team, we agreed that we had no other option. If we wanted to try to reach an agreed understanding with Mr. Worski of how the renegotiated agreement would cover Mr. Anthony's testimony. As I went through my outline with Mr. Worski standing, reading the outline over my shoulder, Mr. Worski declared various subjects that, in his view, would open the door to character, reputation, and extraneous evidence pertaining to Mr. Anthony. During this discussion, Mr. Worski repeated his claim that my earlier mention of chess, he kept saying that, opened the door. While I disagreed with all Mr. Worski's assertions of subjects that would open the door, I agreed to cut from my questioning in the hopes of salvaging the agreement to keep Mr. Anthony's offenses out if he testified. At the end of this discussion, with the understanding that Mr. Worski would extend me leeway to lead Mr. Anthony more than normal through certain aspects of the testimony and an abundance of caution to avoid opening the door, Mr. Worski and I informed Judge Roach that we had come to an agreement as to how the renegotiated agreement would cover Mr. Anthony's testimony, but then summarized the process we had just gone through and our renegotiated agreement on the record. Prior to breaking to allow the defense to retire to the defense room to discuss the issue with Mr. Anthony and his parents, Judge Roach informed us that he was aware of no mechanism at his disposal to enforce the agreement between parties. Are y'all listening? Are y'all listening to this book? Now, this judge, man, this judge done been in 2 meetings with these people about this agreement. He has been in 2 meetings with the defense and the state about this agreement that they had, y'all. Now, right before Carmelo's attorneys are about to call him to the stand, the judge says, I don't know nothing about no agreement, and I ain't enforcing no agreement. You got to laugh to keep from busting a motherfucker upside the head. Like, for real. You got to laugh at this shit. Prior to breaking to allow the defense to retire to the defense room to discuss the issue with Mr. Anthony and his parents, all of them were in the play together to appease the social circle people. Judge Roach informed us that he was aware of no mechanism at his disposal to enforce the agreement between the parties. Furthermore, Judge Roach informed us that he saw no way for Mr. Anthony to testify without the door being open. So he let the state's case be presented with that door being closed. But once it was time for Carmelo to testify, he said there's no way that door wouldn't be open. This motherfucker Judge Roach, I promise you, that motherfucker, oh my God. See, God don't sleep. He do not sleep, y'all. For example, if he said that he brought the knife by accident or said that he was scared, etc., that this would almost certainly open the door to character, reputation, and extraneous evidence of some sort. To clarify the issue, I proposed the hypothetical scenario that if Mr. Worski claimed that the agreement had been breached in some way, if I and even the judge felt that Mr. Worski was opening in bad faith, that the judge was stating that he could not enforce the agreement, would have to make a ruling based on the Texas rules of evidence alone, and that in all likelihood the door would have been open. Judge Roach confirmed that this was the case. We then broke to discuss the issue with our client. Judge Roach gave us approximately 10 minutes to explain the breakdown of the agreement and the proposed resolution with our client before the judge brought Mr. Anthony in for an on-the-record admonishment. During the initial pre-admonishment meeting with Mr. Anthony and his parents, I did my best to explain everything that had just happened with the help of Mr. Shuk and Ms. Gupta. We then returned to the courtroom for Judge Roach to admonish Mr. Anthony about his Fifth Amendment rights and also to explain that if he testifies, Judge Roach believed he had no mechanism to enforce the agreement between the parties and would rule on the rules of evidence alone as to whether the door had been opened. Judge Roach then gave us 10 minutes to discuss his Fifth Amendment rights to Mr. Anthony and help him ultimately decide whether he would testify. I asked for additional time to have such a complicated discussion with a 19-year-old in the most stressful situation of his life, but Judge Roach declined to extend our time beyond 10 minutes. Again, we did our best to explain everything, the pros and the cons of testifying versus not testifying, the likelihood of winning on self-defense if he testified versus if he did not, the likelihood of whether he would get instructions in the jury charge on the lesser included charges of manslaughter and criminally negligent homicide, if he did and if he did not testify, and the likelihood of whether we would get instructions in the sentencing jury charge, if we got there on sudden passion, if he did and if he did not testify. That was a lot. During this discussion, that's a lot for me, and I'm 51. So I know that boy, I know that 19-year-old was like, sir, what? Like, sir, what? During this discussion, beyond all of the above, the most complicating factor of all was whether Mr. Worski would claim that we had opened the door and then bring in Mr. Anthony's extraneous offenses, bad acts, character, and reputation. Based on his actions and claims, specifically his repeated assertions, even after the judge had firmly disagreed that I had opened the door by even mentioning checks, as well as his general claim that the agreement had never contemplated Mr. Anthony testifying, despite the plain meaning of the words Mr. Worski himself repeatedly used to describe the agreement. The defense team felt strongly that the risk of Mr. Worski claiming the door had been opened was too high. This was amplified by the fact that Judge Roach made it clear that should Mr. Worski claim a breach of the agreement, he felt he was unable to enforce it, and that in all likelihood the door would have been open. At the end of 10 minutes, despite our request for additional time, Judge Roach called us back to the courtroom to announce Mr. Anthony's decision and proceed with trial. Ultimately, Mr. Anthony chose not to testify. This 180-degree change in the defense strategy was a direct consequence of the breach of the agreement. The breach of the agreement affected all aspects of the defense case. By the time that the agreement was breached, it was too late to change our approach in jury selection and opening, too late to ask different questions of the prosecution's witnesses, and too risky to recall those witnesses, to ask questions that would risk the prosecution deciding we had opened the door. It greatly hampered our strategy during sentencing, causing us to decide not to call witnesses we otherwise would have called, and severely limiting the questions asked of all of the one witness we did in fact call. The prosecution's breach of the agreement directly and significantly undermined the defense ability to present a complete defense. Wow. And that's the statement of Mr. Mike Howard. Signed, sealed, and delivered. Right there. Exhibit 11 is the certification of undersigned counsel regarding the June 29, 2026 conference and the oral sealing of the court file. So this is talking about Russell, Carmelo's current attorney, right? He's been trying to get the case filed. Actually, he needed the case filed to draft up this motion, but he did not have access to it and still drafted up this bomb-ass motion. I give him applause. But he has been denied access to the court file. So this right here is Russell Wilson speaking, and this says certification of counsel. He says Russell Wilson II certified and states as follows: I am one of the attorneys of record for defendant Carmelo Sincere Anthony on his post-conviction motion for a new trial in the above captioned cause, and I am licensed to practice law in the state of Texas. I was substituted in as counsel on June 23rd, 2026. I make this certification on my own personal knowledge, and the facts that stated below are true and correct. On June 29, 2026, I attended a conference with the court in this case. Counsel for the state and co-counsel for the defendant were also present. So he attended a conference with Roach, Mr. Worski. Roach is the court. Mr. Worski is counsel for the state, and co-counsel for the defendant were also present. At that conference, the court. Hold on now. At that conference, the court advised the parties that the entire court file in this case had been sealed by oral order. The court advised that the file was, in essence, maintained as a paper court file that was not available to the public, and that it was kept for inspection in the court's chambers rather than in the district clerk's public file. The court advised that there was no written order sealing the court file. There was no written order, even though the judge said, look, it's sealed, it's not available to the public. There was no written order for it. The court advised that there was no written order sealing the file, no public notice, open hearing, or findings accompanied the sealing, and I'm aware of no written order authorizing it. The court would not permit the court. Now, this is the attorney for Carmelo who needed that case file to draft this motion. The court would not permit me to review the court file unless I first agreed not to disclose the information contained in it. Is that the current lawyer for Carmelo was told by the judge? The only way I let you read this court file is if you don't tell what's in it. You don't tell what's in it. The court would not permit me to review the court file unless I first agreed not to disclose the information contained in it, and the court would not provide unconditional access to the file. I responded that I could not agree to withhold information that I had not yet seen. I left the conference without reviewing the court file, and I advised the court that I would be back in touch with it. I informed the court that I intended to file a motion for a new trial. I further advised the court that I had not yet decided whether to file a motion to recuse. This certificate, this certification recounts certain statements made in events that occurred at that conference. It is not intended as and does not purport to be a complete recitation of the discussion with the court. It is offered for limited purposes of establishing the necessity of an evidentiary hearing and of addressing the availability of the court file to counsel during the period for filing defendant's motion for a new trial. I declare under penalty of perjury under the laws of the state of Texas that the foregoing is true and correct. So, what the court, aka Judge Roach, tried to do was withheld the court file in hopes that this new dream team would not be able to file this motion in the time allotted. They had 30 days. The dream team had 30 days to file this motion. And what Judge Roach tried to do was prevent them from getting the case filed that they needed to draft this motion. And look at us now. We're reading this motion. Because God don't sleep. And that team meant it was going to file this motion. Judge Roach going down, y'all. I'm telling y'all. That motherfucker going down. He may think he got away with something. He may think, Farm Bear, don't worry. He think he got away with it. But he going down. Exactly, but he ain't know what he was up against. Right. Exactly, Tanya. Exhibit 12. Affidavit of Kiara Key West, member of the public, excluded from the trial. So Kiara was a person that was, and she came from New York. She went to Texas from New York because this was filed in the state of New York. This is an affidavit. She said, "My name is Kiara Key West. I am over 18 years of age, of sound mind, and competent to make this affidavit. I have personal knowledge of the facts stated herein, and they are true and correct. I am a member of the general public. I have no role in this case and no professional media affiliation. I sought to attend the trial in State versus Carmelo Sincere Anthony, a matter of substantial public interest, solely to observe the proceedings. The statements below are based on my own observations. On June 1st, 2026, the day of jury selection, I went to the Collin County Courthouse and sought entry to the courtroom to observe the proceedings. I was denied entry. I was told by the head security officer, Hammond, that the area was restricted only to jury members. There were no signs, posted restrictions, or written policy supporting this claim. When I asked for clarification or supervisory review, Officer Hammond refused to identify or contact an administrative supervisor. I filed a complaint documenting misrepresentation of courthouse policy, enforcement of non-existent rules, refusal to provide supervisory access, and improper use of authority by a courthouse security police officer. No overflow room, alternative viewing location, audio feed, or video feed was made available to members of the public who could not be seated. Had an overflow room been provided, I would have used it to observe the proceedings. I returned to seek access on June 6, 2026, and gained entry, but was later physically removed by Officer Hunt, a police officer assigned to courthouse security. Why though? Why? My God, today. I was removed after making a nonviolent, factual, and protected statement inside the courtroom. Officer Hunt falsely accused me of inciting violence, but I did not raise my voice, threaten anyone, or engage in any disruptive behavior. My removal occurred publicly in view of multiple courthouse police officers and staff. I filed a complaint documenting removal without lawful cause, false allegations made against me, failure to recognize protected speech, retaliatory, retaliatory, y'all know that word. Enforcement, I do too. I just can't pronounce it right now. Enforcement inconsistent. She's saying she was retaliated against for some reason. I don't know. Enforcement inconsistent with courthouse policy and public removal intended to intimidate or silence an observer. After my removal, my son also attempted to enter the courtroom on June 6, 2026. He was wearing a shirt with expressive content. He was asked to turn his shirt inside out by a courthouse security officer and complied. After passing through the security area, he attempted to use the restroom but was denied access by head security officer Hammond. I'm thinking they got Hammock/Hammond because she's not sure what the officer's last name was. She thinks it was either Hammock or Hammond. They did for some reason, Tanya. For some reason. After passing through the security area, he attempted to use the restroom but was denied access by head security officer Hammock/Hammond. There was no signage restricting restroom use, no posted policy, and no legitimate security concern. My son was denied by the same officer who denied me access on June 1st, 2026. I filed a complaint documenting this as retaliation towards a minor and misuse of authority. During the time I was present, I observed a pattern of targeted behavior by courthouse security police officers, including inconsistent enforcement of rules, retaliatory conduct, personal hostility, attempts to restrict access without cause, and targeting both my son and me. During the time I was present at and around the courthouse, I observed no disturbance, security incident, or disruptive conduct by members of the public that would explain or justify excluding the public from the proceedings. Wow. Signed, Kiara Key West. And she went there all the way from New York, y'all. Exhibit 13, Declaration of Jacqueline Denise Young, member of the public excluded from the trial. Let's see what she says. She's from North Carolina. She went there from North Carolina. This lady. She said, my name is Jacqueline Denise. I am over the age of 18, of sound mind, and fully competent to make this declaration. I have personal knowledge of the facts stated below, each of which is true and correct. She said, I'm a member of the public. I traveled from North Carolina to attend the trial in State versus Carmelos and St. Anthony, a matter of substantial public interest, in support of the defendant and to observe the proceedings. I had no role in the case. The statements below are based on my own observations during my efforts to attend the proceedings, except where I state I was informed of a fact by others. The proceedings I sought to attend. I arrived in the Dallas area on June 3rd, 2026. I hope to attend the trial beginning with the first day of testimony after jury selection. On June 4th, 2026, the first day of testimony, I went to the Collin County Courthouse to observe the proceedings. June 4th, 2026, only approximately 27 members of the public were admitted. I arrived at the courthouse at about 8 to 8:30 a.m. There was no line outside the courthouse, so I went inside and went upstairs, where I found a long line of members of the public, about 80 to 100 people. I took my place at the back of the line, and the others continued to line up behind me. I briefly left the line to use the restroom and returned at about 9 o'clock. When I returned, I saw that the line was dispersing. Only about 27 members of the public were admitted into the courtroom, and I was not among them. An overflow room had been used, but the rule changed that morning. Before June 4th, I was informed by friends. This is where she's saying, I'm stating facts that somebody told me to as well. She said, before June 4th, I was informed by friends who had attended that that court staff had been admitted. Let me stop. Let me slow down. Woo. Before June 4th, I was informed by friends who had attended that court staff had been admitting members of the public into an overflow room and had been letting in as many people as there were seats available. On June 4th, that practice changed. I understood that the rule had been changed that morning so that only about 27 people would be admitted, and no overflow room was made available to the many others who sought to attend. She said, I remained at the courthouse but was unable to gain entry on June 4th. I spoke with a couple of sheriff deputies to ask why more members of the public were not being admitted. I was told that this was simply the rule for that day. As far as I was able to determine, the same restriction remained in place for the rest of the week. The deputies told me that if a person left after the lunch recess and did not return, another person might be admitted in their place. But given how strict the rules were, I did not attempt to gain entry in that manner. Because of these conditions, I decided to spend the remainder of the week outside the courthouse with the other members of the public who had gathered there and were unable to get in. I was informed by other members of the public that some of them had arrived at the courthouse as early as 3 or 4 o'clock a.m. and still had not been able to gain entry. She said, during the times I was present at and around the courthouse, I did not observe any disturbance, security incident, or disruptive conduct by members of the public that would explain or justify excluding the public from the courtroom. She signed it and it's stamped. And that's her statement. Exhibit 14 is the declaration of Tira Allen. Tira Allen was from Arizona. These people came from everywhere. You hear me? These ain't people that was in Dallas, that lived in Dallas, right? These are people that traveled to attend this trial, right? So Tira says, my name is Tira Allen. I am over the age of 18 and of sound mind and fully competent to make this declaration. I have personal knowledge of the facts stated below, each of which is true and correct. I am a member of the public. I flew in from Arizona on Saturday, May 30th, 2026, to attend the trial in State versus Carmelo Sincere Anthony, a matter of substantial public interest. I had no role in this case. Because the trial schedule changed and because it was difficult to gain entry to the courthouse, I changed my return airline ticket 3 times, from Tuesday to Thursday and finally to Saturday, to coincide with the proceedings I hope to observe. The statements below are based on my own observations during my efforts to attend the proceedings, except where I state that I was informed of fact by others. On Monday, June 1st, 2026, I attended and was able to watch the jury selection proceedings from an additional viewing room, which I understood to be referred to as the Oval Room. On Wednesday, June 3rd, I again attended and was able to observe the jury selection proceedings. On Thursday, June the 4th, 2026, the first day of testimony, I arrived at the courthouse at about 6:30 a.m. and I was told that based on the judge's instructions, the deputies were not permitting anyone into the courthouse parking lot until 6 o'clock a.m. When I arrived at 6:30 a.m., members of the public were already lined up inside the building. When I asked others what time they had arrived, some people near the front of the line said they had lined up outside the courthouse by about 5:45 a.m. before the 6 a.m. time the judge's instructions had set access to the property. I pointed I pointed this out to two deputies whose names I understood to be Hunt and I believe Holcomb. I stayed in line that day, but was not able to get inside the courtroom. When I asked about an overflow room, I was told that the courtroom where the trial was taking place was the only room that did not have video conferencing, aka Zoom, capability or the ability to record, and that this was given as the reason no overflow feed was provided. Jury selection had taken place in a different courtroom. Other attendees and I asked whether we could be seated in the room we had used on Monday and Wednesday in order to listen to the proceedings, but we were told no, and that the judge had said there was no overflow room. Um, Too many non-whites. Tell you crazy girl. I wonder if any white people had these issues because I could pretty much tell and don't know for a fact, but these people were black. I'm willing to bet. I'm willing to bet cold hard cash these people were black. We know Neek is black, so I'm willing to bet these other people were black too as well. Um, on Friday, June 5th, 2026, I arrived at the courthouse at about 6:04 a.m. There was no direction given to arriving members of the public. I asked the deputies how they were controlling the line because people were walking up and joining others they knew who were already in line. And, and some people were displaying a badge and claiming to be media, even though credentialed media should not have been standing in the public line. The deputies told me that they did not have instructions on how to control the line, that it was up to the attendees how they lined up, and that they were only to keep things calm. Each day, a group of people claimed to be media, but did not appear to be credentialed media. They may have operated social media platforms, but did not have a media pass. The 9 individuals who held designated media passes would arrive later, obtain their passes, and go directly into the courthouse without waiting in the public line. On both Thursday, June 4th and Friday, June 5th, I was not able to gain entry to the courtroom. On each day, I waited until after the lunch recess, but I remained too far down the line to have any realistic opportunity to be admitted. On Saturday, June 26th, I was at the courthouse at about 4 o'clock a.m. waiting and driving around the property. The parking lot was barricaded so that cars could not enter as they had before. At about 5:30 to 5:40 a.m., I noticed a line beginning to form outside the entrance to the courthouse. So I was dropped off at the corner in order to join the line. The officers told another attendee that if the attendees created a number system, the officers would honor it, and that this was how the attendees would be admitted. The attendees did create the attendees did create a number system, and under it, I was number 15. When we were told we could enter, however, everyone ran to the courthouse and the number system was not honored. Court staff admitted the first 27 people. I was the person immediately after 27. I was ultimately able to get in after the lunch recess. She says, what page is this? Ooh, shit, it's still like 30 some pages. Oh, and I don't remember what was on those pages, so we're gonna keep going. My other live, well, I'm gonna have to reschedule that second live, and then I'll do the T channel live. This is crazy. I didn't know this was gonna take this long, y'all. I'm sorry, but we're gonna do that update live definitely tomorrow morning. I gotta give y'all the updates on this other stuff. Who, child, y'all pray for me, okay? Mm-hmm. Okay. She said, From my understanding, there were 9 media passes and 27 passes for members of the public. Credentialed media, press, and news personnel had designated passes and did not have to stand in line. On multiple occasions, individuals who operated social media platforms told the deputies that they were media and were allowed to move to the front of the line, ahead of members of the public. Attendees objected to the deputies that persons claiming to be media should not be standing in the public line, and that if they were in the public line, they should not be permitted to cut ahead. Each time, the deputies responded that they had been instructed only to keep things calm and did not know how to control the line. Thank you, Tanya. She said, during the times I was present at and around the courthouse, I did not observe any disturbance, security incident, or disruptive conduct by members. Y'all notice that every witness is saying this at the bottom. And there's a reason for that. Because the reason for this statement right here is to let the courts know that there was no reason, absolutely no reason for the judge to not permit the public inside that courtroom, because there were no, even though, you know what I'm saying, it was like a intense trial, and you had black people out there, you had white people out there, there was no disruptions. Like, there was no reason for him to act like, you know, he was securing the White House or some shit. So all of them are swearing to this statement that during the times I was present at and around the courthouse, I did not observe any disturbance, security incident, or disruptive conduct by members of the public inside the courthouse that would explain or justify excluding the public from the courtroom. Over the course of the week, I was able to observe the jury selection proceedings twice, and I was able to enter the trial itself only on Saturday, June the 6th, after the lunch recess for about 3 to 4 hours. All right. Exhibit 15, Tamitra Carter. Again, didn't we do Tamitra? She got something else to say. Now, Tamitra was from Dallas, Texas. Why do I think this is what you call it? But I don't know for sure. I don't know her name. Well, I think this is old girl. I don't know why I feel that way, but I do. My name is Tamitra Carter. I am over the age, blah, blah, blah. That's the same thing they all say. I'm a member of the public. I got no role in the case. The statements below are based on my observations. Okay. She said, I went to the Collin County Courthouse on June 4th, 5th, and 6th in efforts to observe the trial proceedings. On June 4th, I arrived at about 6 a.m. There was already a line of members of the public waiting to enter the courtroom. Because of the limited number of public seats available, I was unable to obtain a seat in the courtroom that day. I understood that the court's order set a specific time for the admission of the general public. On June 5th, 2026, I arrived at about 4:30 a.m. and was among the first members of the public to arrive. When I arrived, I was informed that I could not remain at the courthouse because it would not open until about 6. Members of the public were directed to wait at a nearby church until we were allowed to return. Before leaving the courthouse area, a member of the media recorded my initials and advised me that I was number 7 on the personal list he was maintaining of early arrivals. At about 5:30 a.m., members of the public returned to the courthouse. I was the first vehicle waiting to enter the parking lot, and additional vehicles lined up behind me. Before 6 a.m., the sheriff's deputies temporarily moved away from the entrance. After hearing the vehicles behind me honk, I believe we were being allowed to enter and slowly pull forward. When I saw the deputies returning, I immediately stopped because I did not want to enter before I was authorized to do so. After I stopped, 2 vehicles behind me were involved in a traffic collision near the entrance to the courthouse parking lot. Law enforcement responded to the collision, and afterwards we was instructed to proceed into the parking lot. After parking, I attempted to approach the courthouse but was instructed to return to a stop sign and line up there. By the time I reached that location, about 20 or more people were already standing ahead of me, even though I had arrived among the first members of the public that morning. I ultimately found myself approximately 35th in line. I explained to one of the sheriff's deputies that I had arrived early and did not understand how I had lost my place in line. I asked whether the line could be organized according to the order in which people had arrived, but my concerns were not addressed. I then spoke with the same media representative who had recorded my initials earlier that morning. He confirmed that I was number 7 on the list he had created. He attempted to explain this to the lead sheriff's deputy, whom I believe was named Brasco or Brosco. The deputy did not recognize the list and directed that I be removed from the line after believing that I had been skipped ahead. Because only about 27 seats were available to members of the public, being removed from the line prevented me from observing the morning proceedings on June 5th. On June 6th, I arrived at about 3 o'clock a.m. Damn. Because there was no official numbering system maintained by the court, members of the public created and maintained our own numbering system while waiting in line in an effort to preserve the order in which people had arrived. To the best of my knowledge, I still possessed a photograph documenting the public numbering system that was used that morning. Members of the public were instructed to run, not walk, when approaching the courthouse. What? So what the police told them, look, form a single file line and don't run, walk. What the hell was going on, y'all? To the best of my knowledge, okay, members of the public were instructed to run, not walk, approaching the courthouse. On June 6, 2026, I was admitted to the courtroom and was able to observe the proceedings. Right, Tony, that's crazy. What are we in kindergarten? What the hell? People had to run if they wanted to get in. This shit was ridiculous. This was chaotic to me, even though, they say there's no fights and nothing break out. But this was, getting into this trial was stressful. Shit. Hold on, let me sure I ain't skipped that. Okay, I think I went back too far. Hold on. Yeah, I did. I did. I did. Okay, now let's go to 16. Declaration of Bridget Smith. She said the same thing, basically, being sworn in and da da da. I'm a member of the public, blah blah blah. She said, now let me see where she was from. She was from Dallas too, as well. She said on June 1st, 2026, I attended for the jury questionnaire session. I understood the questionnaires would be completed that day and that jury selection would begin later that week. When I arrived, I asked the court coordinator where members of the public would be permitted to observe and whether any accommodation would be available, given the significant public interest in the case. Officer led us to a room to sit, and it was my understanding and everyone else's that we would be able to view the jury selection from there. We sat in the room for about an hour and began to ask questions. And someone came in and told us that the jury selection was being held upstairs while we were all downstairs. We got up to see for ourselves and found a room full of people down the hallway. Out of what appeared to be roughly 600 people, we saw only a handful of black people. Wow. What? One of the officers from the room where we had been seated came and told us we could not be down there and that we needed to go back because they did not want us to taint the jury pool. I responded that if that was the concern, I did not understand why White Lives Matter had been allowed to pass our propaganda about the case to people going in. A paper using the word in Austin's murder, which I was concerned would already taint the pool. We were sent back to the room where we were not permitted to even view the proceedings on a television, and we were told we would not be seeing anything. In effect, we would be sitting in the room the entire day for no reason, and no one was going to notify the people sitting there. We let the others know, and most people left, deciding to return Wednesday or Thursday. I understood that the court's order set a specific time for the admission of the general public. We were told we had a time to get in the courtroom and that we could not bring phones in, and people were even moved around in seating, only for us to learn on our own that they were going to allow us to sit there all day and view nothing. She said the courthouse was closed on June 2nd, 2026. Jury selection began on June 3rd. On June 3rd, 2026, I decided not to attend jury selection, but to attend on the first day of opening statement, which was Thursday. On June 4th, 2026, the first day of testimony, the court eliminated the additional viewing location. From that point forward, public access was limited to about 27 seats inside the courtroom. No overflow room, alternative viewing area, auto feed, video feed, or other accommodations were provided. When we arrived, there was a very long line of people in two lines. One was for the people on the media list, and the other was for everyone else. When they cut it off at 27 people, we asked whether there was an overflow room and was told no. Public seating inside the courtroom was limited to about 27 seats. Although the court's order stated a time for public admission, in practice, admission was determined by how early a person arrived in that person's place in the informal line, not by the time stated in the order. Members of the public began arriving as early as 4 o'clock a.m. to 5 o'clock a.m. to compete for the few available seats, and those who arrived after the line had formed often had little or no realistic opportunity to be admitted. Oh boy. On June 4th, 2026, I was unable to gain entry to the courtroom and was excluded from that day's proceedings. I stayed in the parking lot with the others who had been turned away. Some people left. Some had driven in from other states and deciding they would not have an opportunity to observe made plans to travel back home. On June 5th, 2026, I again attempted to attend and was again unable to gain entry because of the limited seating in the admission process. We learned that when people took breaks, they were told someone else could take their spots. So we went up to try to obtain a spot, but only about 6 or 7 seats were available for passes. As a result, some of those who had been waiting were, were able to go in, while some of the people who had left on their breaks were not able to regain access. On June 6th, I did not make it to the courthouse, but other people who had come with us decided to go and keep us updated. Mm-mm-mm. Let me see. During the times I was present in the courthouse, women, during the times I was present, I was present in and around the courthouse. I did not observe any disturbance, security incident, or disruptive conduct by members of the public that would explain or justify excluding the public from the courtroom. Yet I watched court personnel remove people to whom they had given passes over small petty matters. One of the male reporters from South Carolina who had been present from the beginning, was made to leave. as was another woman who had been inside. In my observation, neither of them did anything to warrant removal, and I believe the reporter's rights were violated because they attempted to tell him what he could and could not say. And when he tried to assert his rights in a public courthouse, they told him to leave. My God, today. On June 4th and June 5th, in the morning of June 6th, I and other members of the public were unable to observe the proceedings. The seats were available to the public were few. The additional viewing location used during jury selection was discontinued once testimony began, and my ability to observe the proceedings were significantly curtailed as a result of the limited seating, the elimination of the overflow room, and the manner in which access was administered. All right. Okay, now we got a Tony Toussaint. She was from Louisiana, and she says, let's see. Hold on 1 minute, y'all. Give me a second. All right. Let's see. This person was from Louisiana. Tell by the name. Oh, wow. This is Carmelo's grandmother, y'all. This is Carmelo's grandmother. Tony Toussaint. She said, "My name is Tony Toussaint. I am over the age of 18. I'm of sound mind, fully competent, blah, blah, blah." She said, "I am the grandmother of Carmelo Anthony. I attended the trial proceedings in this matter as a family member of the defendant." Uh-oh, it's going to get good now. She said, family seating was limited to 8 seats. Before the trial began, my daughter told me that access to the courtroom would be limited for family members. I subsequently learned that the family was limited to a total of 8 seats in the courtroom. I understood that the remaining seats were reserved for journalists who had been individually selected to attend and for members of the general public. So they took 7 of Carmelo's family members' seats for the public. So in actuality, with their lying asses, they afforded the Metcalfs 15 seats, but only allowed it 8 seats for the Anthony family. That, in the midst of all of this, that's petty, but it just shows you how petty they were towards this family, and it shows you how the level of fuckery went from a petty level all the way up to a disgusting level. This is ridiculous. So not only are you railroading this kid, right? You being petty. You said it was supposed to be 15 seats for his family, 15 seats for the other family, but they get 8. Like, these motherfuckers. boy, I tell you. She said, um, mm, in order to attend, family members were required to arrive at the courthouse by 8 o'clock and to obtain badges. In addition, a family member's name had to be placed on a list the day before in order to be admitted the following day. Before we left the courthouse each day, court staff would ask whether we intended to return the next day so that our names could be added to the following day's list. She said, my attendance and the exclusion of other family members. Because I was able to secure one of the 8 family seats, I was able to be present inside the courtroom each day of the trial. My husband, Carmelo's grandfather, was not able to attend because of the 8-seat limit on family access. Carmelo's aunts, among others, were likewise not able to attend for the same reason: restrictions on conduct inside the courtroom. The judge instructed attendees that we could not speak while inside the courtroom, and we were told that if we did so, we would be held in contempt. We were also told that if we made a facial expression, we would be removed from the courtroom. Bullshit. Bullshit. They couldn't talk, y'all. They couldn't smile. They couldn't cry. They couldn't frown. They couldn't do nothing. Family access to the courtroom was limited. She said conditions are observed. Family access to the courtroom was limited to 8 seats total, which I understood to have been allocated among Carlos' many family members, alongside seats reserved for selected journalists and the general public. Although I was able to attend each day of trial, the 8-seat limit meant that other close family members, including Carmelo's grandfather and aunts, were not able to attend at all. Attendance also required advance registration each day and compliance with strict conduct rules inside the courtroom, including a prohibition on speaking and a warning that visible facial expressions could result in removal. Mm-mm-mm-mm. Declaration of Thelma Anderson, and this is an email. Well, it says something about the email. How many more pages is it? Hold on, let me see something. So that's page 172. Let me see what's left. Oh, okay. So after Thelma, it's gonna be I'm gonna get to that. So I'm gonna keep going. I'm motivated. This is the jury. The jury. This is the jury. Damn, I can't get it out, y'all. Y'all know what I'm saying. Instructions to the jury is what this is, and I think that's gonna be it. Yeah. Oh, affidavit on the kill Washington. All right, I'm gonna do this, y'all. I'm gonna do Thelma, and then I'm gonna do Nikhil, and I'm gonna do the instructions to the jury last. All right, so this is Thelma's declaration. Let me take some water, y'all. Listening to this angers me more and more because how the fuck were they able to get away with this? Yeah, yeah. Almost done, y'all. And it only took what, 3 days? Um, my name is Thelma Anderson. I am over 18, blah blah blah. I'm a member of the public. She said, I'm a member of the public. I had no role in the case. I sought to observe the trial proceedings in State versus Carmelo Sincere Anthony, which were of substantial public interest. Although the trial was technically open to the public, the practical limitations imposed by the court substantially restricted meaningful public access. The statements below are based on my own observations and on the emails I sent and received during my efforts to attend the proceedings. Give me a second now. Trying to keep myself. Hold on. I'm about to run to the restroom, y'all. I'll be right back, okay? What y'all saying? Listen to the. What's sad is Carmelo is not the first and unfortunately won't be the last. Well, you know what? That's why I hope that judge get some type of, like charges or something. Because if that happens, then they'll have to go back. They'll have to go back and pretty much scrutinize all his cases. I think y'all had talked about that before in the chat. They'll have to go back to all of his cases and review them pretty much. You know what I'm saying? I'll be right back, y'all. I'm gonna go to the restroom. All this damn water I've been drinking. Let me turn some music on. Try to turn something upbeat on. Let me see. Y'all don't like the rock and roll? I love rock and roll. Tell you, I love rock and roll, girl. Dun, 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 dun. Girl, you know I'm very multi-musical. Come on now. At least I ain't put no opera on. I ain't put Beethoven on. So I just saying we are not the rock and roll type of family members. Listen, you can do rock and roll, girl. You ain't like Guns and Roses and them. That was not horrible, Melissa. That was not horrible. Stop it. You're doing too much. That was not horrible. Y'all gotta stop. True pull the gate. That's why me and Gabe, that's why we resonate. I love Beethoven. Come on, Queen. I put Beethoven on, don't do that. I put Beethoven on, don't do it. That's why me and Gabe love the same type of music. I love rock and roll. Y'all crazy. Mm-mm. All right. We're gonna finish this today, y'all. If we have to leave here and go straight over there to the T, we'll all wake up by then. But that one I had scheduled for 12, the one with the updates. In fact, let me do that right now, y'all. I'm gonna do this while y'all on live so y'all can keep me honest. Let me see. Let me go to my StreamYard and I'm gonna reschedule it. Tell her, Tanya, we was smoking Sade. We already halfway sleep. You talking about smoking Sade? Girl, we'll be sleep, girl. Girl, we'll be sleep. Baby, let me play cruising. I'm going to sleep. Or let me play, let's get it on. I'm going to get off of here. Let me play Sade. I'm going to sleep. What page we on? Girl, we on Crime and Justice. Where? Natasha. Oh, Jesus. Oh, now you making me question where I am. I know it's been a long morning, but damn. Natasha, you don't know where you at, girl? Ooh, Natasha. Page off the document truth. OMG. What? Page of. Oh, you said of. Page of the document. Are we on page 172? We on page 172. Y'all is crazy. Oh my, I can't wait till we get together. Cause I know it's gonna be a fun time. Cause all y'all motherfuckers just as crazy as me. I'm just saying. Now, what time should I schedule this morning, this live in the morning? Because I'm gonna need y'all to be here. Because if I get up early on a good Saturday morning, right, and do this live, y'all need to be here. So what time should I reschedule the live that I got for the updates on JaVale and Nolan? Y'all let me know now. Let me know real quick. What time should I schedule it for? 9 or 10. It's not gonna be any later than that, because you know we still gotta go over there to the T channel. So y'all want it at 9 or 10? Let me know. Oh, it's got to be early because I got to get through by. I forgot about my daughter's birthday dinner. It might be 9, y'all. It might be 9 for real. Because I got to do that live and then I got to do. Because if I do it at 9, it's going to be 8 some of y'all time. 10. Okay, I'll do it at 10. But I got to do this live and I got to do a short T live. I might not do a T live tomorrow, which is going to piss some people off. But I got to be done by 3. I got to be done by 3, y'all, with both lives because my daughter's dinner starts at 6. I'll do 9. I'm going to be pushing it once again, but let me change it right now. I know some of y'all are Easter. Okay, I just thought about that. Let me see. All right, y'all. I did it. Oh shit. I put 9. I fucked up. Hold on. Damn. I know, Tosh. Yeah, y'all. All of y'all are ahead of me. All right, so I put it at 10, y'all, and it's gonna be 11 for y'all. But if I put it at 9, it's gonna be 10 for y'all. Oh, so I can put it at 9, right? I can put it at 9 my time, right? I can put it at 9 my time. It's gonna be 10 for y'all. So I can put it at 9 for me, right? Okay. Okay, great. So it's 9 for me, it's 10 for y'all. Okay, great. All right. So it's scheduled for tomorrow, y'all. In the morning at 9 o'clock. That's gonna be our update live, okay? Okay. Oh, I just got an alert. Remains found in Javale Harris case. DNA evidence confirms remains in the reservoir belonging to missing 4-year-old girl. So, yeah, I gotta do my update live, y'all. I gotta do my update live. But it's gonna be done tomorrow morning, okay? God willing. I will be there. Y'all be there, be square now. I'm gonna get up early. Because we gotta talk about it. I'm gonna get up early. Well, not early. Early. I get up anyway, but sometimes if I don't have nothing to do, I get up and I go back to sleep. But I'm gonna do this live. All right, y'all. Let's finish this up. So, this is Thelma. This is Thelma. Is it Anderson? Yeah, Thelma Anderson. This is her affidavit. Truth on me did a detail up. Carlos, I got it. Don't worry, baby. I get all callers. All callers. I get him. Thank you, keep it cute. I got it. He sure did. I got it. Thank you. Let's see. She said, my name is Thelma Harris. I'm 18 of age. Okay, yeah. She said, I'm a member of the public. I had no role in the case. I sought to observe the trial proceedings in State versus Carmelo Sincere Anthony, which were substantial public, which was of not y'all man. Yeah, that's how I'm man, girl. What's wrong with you? Natasha, you didn't know that? me and Fun, me and Cuba Q are closer than close. We got the same man. Closer than close. I'm gonna need you to get with it, Natasha. Although the trial was technically open to the public, the practical limitations imposed by the court substantially restricted meaningful public access. The statements below are based on my own observations and on the emails I sent and received during my efforts to attend the proceedings. On June 1st, 2026, I attended the courthouse for the jury questionnaire proceedings. I understood that the questionnaires would be completed that day and that the jury selection would begin later in the week. I approached the court coordinator to ask where members of the public would be permitted to observe and whether any accommodations would be available, given the significant public interest in the case. I believe I read this one already. I think I read this one. I think the only reason why they put this back in here is because she has an email. I'm gonna skip this, y'all. I read Thelma's, and I thought I did, but I was tripping. Okay, wait a minute. Let me go back up because this looks different. I'm gonna just read it. Might as well. On June 3rd, 2026, wait a minute. Okay. On June 3rd, 2026, the court provided an additional viewing location outside the courtroom where members of the public could observe the proceedings. Although court personnel referred to the room by another name, it functioned like was is commonly known as a jury service or holdover room. This arrangement allowed members of the public who could not fit inside the courtroom to observe the proceedings and reasonably accommodated the substantial public interest in this case. On June 4th, 2026, the first day of testimony, the court eliminated the additional viewing space and limited public access to about 27 seats inside the courtroom. No overflow room, alternative viewing area, or additional accommodation was provided. Public access was thereover limited exclusively to the small number of seats inside the courtroom. Although the court's order specified a time for public admission, the practical reality was very different. Individuals began arriving at the courthouse during the early morning hours, often between 4 a.m. and 5 a.m., to try to secure one of the limited seats. The process became comparable to a to a race for access, with members of the public competing for a very small number of seats. Those who arrived after the unofficial line had formed often had little or no realistic opportunity to gain admission, regardless of the time stated in the court's order. In practice, access was determined not by the scheduled admission time, but how early a person arrived and whether the person was able to secure a favorable place in line. This system effectively excluded many members of the public from observing a trial that had generated substantial public interest. Interest. Because of these restrictions, I was unable to gain entry to the courtroom on June 4th, 2026. If there had been if there had been an overflow room, I would have went to the overflow room. On June 5th, 2026, I again attempted to attend the proceedings but was unable to gain entry because of the limited seating and admission procedures. My request for alternative viewing location was denied. Recognizing the severe limitations being imposed, I submitted an application seeking media credentials and also requested that the court provide an alternative viewing location for members of the public. My request was intended to address the obvious capacity problem and to restore a level of access similar to what had been provided during jury selection on June 3rd. My request was denied. The process for seeking relief was itself problematic. Collin County's electronic filing system did not provide a mechanism for filing applications related to courtroom access in a criminal proceeding. Because the matter was a criminal case rather than a civil action, there was no designated filing category available through the standard e-filing portal, and I could not formally file the application through the court's electronic filing system. Instead, I was instructed that such requests had to be submitted by email directly to the court coordinator, who would then forward the request to the Public Information Office for review and response. This procedure left no transparent or clear avenue for members of the public to formally seek judicial review of the access restrictions. On June 5th, 2026, I received an email from Steve Stoller. We all know who Steve Stoller is. He's the PIO, Public Information Officer, right? Lighter going out. That ain't gonna work for me. Hold on now. On on June 5th, 2026, I received an email from Steve Stoller, who identified himself as the public information officer appointed by the 296th District Court for this trial, responding to my inquiry about media coverage and courtroom access. In that email, Mr. Stoller explained that the courtroom held only about 70 seats, that the prosecution and defense families each received 15 seats, that the judge allocated only 9 seats for the media, including one for a courtroom sketch artist. Um, and that after court staff, only about 2 dozen seats remained for the general public. He further stated there was no overflow room. A true and correct copy of that email, which I received and retained in the ordinary course, is attached as Exhibit A. Throughout that email, Mr. Stoller described the courtroom access decisions in the collective first person. He wrote that he wished to explain the process we followed for media coverage, that we chose 8 media outlets for credentials, that we invited media members who were not approved for credentials to gain access with the general public, that we encouraged them to get in the line early, and that as much as we disliked turning people down, we had no choice. The email's repeated use of "we" reflected my understanding that the selection of who would be admitted to observe the trial and the denial of access to others was administered by the public information officer rather than determined by the court in open court and on the record. The explanation I received: those accommodations have been limited to local media organizations covering the case, did not, based on my observations of who was receiving access, appear to fully account for all individuals who had received accommodations or special access. Regardless, my request for an alternative viewing location was denied. Note taking restriction. The original guidance provided to individuals seeking access indicated that members of the public would not be permitted to bring notepads or pens into the courtroom. Although the court later modified this restriction and ultimately permitted notepads and pens, the original, I don't know why I stop at this word every time, prohibition, y'all know, reflected reflected the broader pattern of limiting public observation. Now I don't understand. This is the thing. I don't get how you allow these people into the courtroom to listen to, observe, and report on this court proceeding without allowing them some type of device or pen and paper to write down notes. Who does that? Now, they did lift the whole, no pen and paper, but initially they said no pen and paper, no devices, no nothing. So what the hell? Anywho, moving on. She said on Saturday, June 6, 2026, I returned to the courthouse and arrived early to try to secure one of the available seats. By that point, courthouse personnel and sheriff's deputies had implemented a line system for admission. I initially obtained a position near the front of the line and reasonably believed that I would be admitted. The line process, however, lacked transparency and consistency. During the waiting period, individuals were permitted to move ahead of others who had already been waiting for several hours. As a result, despite having arrived early and secured a favorable position, my place in line significantly changed, and I ultimately found myself about 35th in the line, even though only 27 seats were available to the public. I was again excluded from the morning proceedings. After I was excluded from the morning proceedings on June 6th, I remained at the courthouse for several hours. Had an overflow room been provided, I would have gone to it and observed the proceedings from there. Instead, I waited in the hallway for a considerable time, and with no access to the courtroom. In each instance in which I was excluded, I could I could observe that additional members of the public were excluded along with me. I was ultimately admitted to the courtroom in the afternoon of June 6, 2026 at about 2 to 3 p.m., but only after substantial portions of that day's proceedings had already occurred so that I was able to observe only a portion of the defense's case. Shit, the defense ain't had no case. You ain't missed nothing. You ain't what you missed was a lot because it wasn't a lot. So if you missed some of it, you missed a lot because it wasn't none. Like honestly, it wasn't. Hold on, y'all. Sorry, I was reading something. Um, let me see. During the times I was present in and around the courthouse, I did not observe any disturbance, security incident, or disruptive conduct by members of the public that would explain or justify excluding the public from the proceedings. Everybody gonna make that statement because they want to make it be known he had no reason to do what he did. Summary. While the courtroom may have been technically open to the public, meaningful public access was severely restricted in practice. Access depended upon arriving before dawn, enduring hours of waiting, navigating an informal and often changing line process, and competing for a very limited number of seats. The court's decision to discontinue the overflow viewing room that had been used during jury selection further exacerbated these problems, and requests for reasonable accommodations and alternative viewing arrangements were denied despite the obvious demand and the court's own prior use of an auxiliary damn, I know that word. I know how to pronounce it. Auxiliary room during jury selection. As a result, members of the public, including me, were repeatedly denied the ability to observe significant portions of a criminal trial of substantial public interest. The effect of these restrictions will substantially impair the public's ability to monitor, observe, and reevaluate the proceedings. That's why he did it. Shit. Roach knew what he was doing with his low down ass. I hope he be the first somebody to get it. But y'all do know that Mr. What his name? The prosecutor. What was his name? He need to get it too. He need to get it too. Um, so this is an email from Steve to Thelma. My name is Steve Stoller, the 296th District Court appointed yours truly as the public. Oh, God. He need to go in because that seems like a copy and paste type thing he got. He need to go and correct it because he got public misspelled with his dumb ass. I wanted to take the time to explain the process we follow for media coverage. To set the stage, I've already read this. He sent this to Neek, so I'm not gonna reread that. He sent that same email that he sent to Neek to them. Neek at night. I'm not gonna read that again. Now, I said I was gonna skip this and go to the last lady and come back to that. It's 3:00. Damn. All right, hold on. I gotta hurry up. So this is Nikhil Washington. This is another member of the public. Okay. She said, I'm a member of the public. This is Nikhil Washington, y'all. She was from Ohio. She went to Texas from Ohio. She said, I'm a member of the public. I had no role in the case. I sought to observe the trial proceedings in this matter in which of substantial public interest. I traveled from Cincinnati, Ohio to Dallas, Texas, arriving on May 29, 2026, specifically to attend the proceedings. The statement below is based on my own observations made during my attendance at the Collin County Courthouse on June 1st, 3rd, 4th, 5th, 6th, 8th, and 9th, 2026. I went to the Collin County Courthouse to observe the proceedings on June 1st. June 4th, okay, I just said that. On June 1st, I attended the jury questionnaire session. Upon arrival, I was in the wrong area of the courthouse. A sheriff's deputy stopped me and directed me to the memorial room, where members of the public would be permitted to observe. Deputies, deputies present indicated they were uncertain whether we would be able to view anything, but advised us to wait. After about 2 hours, at around noon, screens in the memorial room came on, and we were able to observe the judge speaking to the prospective jurors via live video and audio feed. The process that day was straightforward and without difficulty. The court's order set a specific time for the admission of the general public. In practice, however, access on later dates will govern not by the time but by a person's place in an informal line that began forming well before that hour. The courthouse was closed on June 2nd. Jury selection began on June 3rd. On June 3rd, the court again made available an additional viewing location outside the courtroom where members of the public could observe the proceedings. Court personnel referred to it as the memorial room, but it functioned as a viewing courtroom. It was a separate courtroom that held about 60 members of the public and provided a live video and audio feed into the central jury room, allowing those present to observe the jury selection proceedings. The line on June 3rd was short. Entry was without difficulty, and I was admitted without issue. On June 4th, the first day of testimony, I and others who had arrived and waited in line were informed only after arriving that the overflow viewing room would not be made available for the remainder of the trial. From that point forward, public access was limited to about 27 seats inside the courtroom. No overflow room, alternative viewing area, audio feed, video feed, or other accommodation was provided to those who could not obtain one of those seats. Public seating inside the courtroom was limited to about 27. Although the court's order stated a place for public admission, in practice, admission was determined by how early a person arrived and that person's place in an informal line, not by the time stated in the order. Members of the public began arriving as early as 4 o'clock a.m. to 4:30 a.m. to compete for the few available seats, and those who arrived after the line had formed often had little or no realistic opportunity to be admitted. The line process was inconsistent from day to day, at times chaotic, and on multiple occasions generated visible tension and disputes among those waiting. On June 4th, 2026, I was unable to gain entry to the courtroom and was excluded from the morning proceedings. After the line dispersed and most members of the public departed, I chose to remain at the courthouse on my own. At about 2 o'clock p.m., Sheriff Hunt approached me as I was one of only 2 or 3 individuals still waiting and informed me that seats had become available. He escorted me inside and I was admitted to the afternoon proceedings. By that time, a substantial portion of the day's proceedings had already taken place. On June 5th, I arrived at about 5:50 a.m. Members of the public were already present and a line had begun to form. A traffic accident near the courthouse entrance caused additional disruption as people arrived. Deputies directed those of us who had exited our vehicles to form a line on the grass in front of the courthouse steps, and then subsequently to form a line at the courthouse door. The process was chaotic and generated tension. Um, Several verbal altercations occurred among members of the public. One individual was removed from the line by a deputy and informed he would not be permitted to enter the courthouse that day after a dispute arose over individuals associated with the Metcalf. Hold on. Back it up. What had happened? Hold on. Yeah. One individual was removed from the line by a deputy and informed that he would not be permitted to enter the courthouse that day after a dispute arose over individuals associated with the Metcalf family being permitted to move ahead in line without being directed to the back. What? At 7 o'clock a.m., the first 27 individuals were counted out, escorted inside, and issued badges. The remaining members of the public were permitted to wait in the courthouse corridor, where a bench across from the courtroom had about 8 or 9 individuals who were next in line as seats became available. I was admitted to the courtroom after the lunch recess at about 1 o'clock p.m. Substantial portions of the morning proceedings had already occurred by the time I entered. On June 6th, I arrived in the area surrounding the courthouse at about 4:30 a.m. Members of the public were not permitted into the courtroom grounds until 6 a.m. At that time, a line was formed on the grass in front of the courthouse. I was among the first 27 individuals counted out. Those 27 of us was escorted to form a line near the courtroom door, while the remaining individuals were directed to the opposite side of the building. Deputies stated this separation was intended to reduce the deputies to reduce the disputes and line skipping that had occurred on the prior days. I was admitted to the courtroom that morning and was present for the morning proceedings on June 6th. On June 8th, I arrived at about 4:15 a.m. A line had already begun forming on the sidewalk outside the courtroom entrance. Though we were not permitted into the courthouse grounds until 6 o'clock a.m., several individuals with independent media credentials attempted to use those credentials to advance in line. Deputy Holcomb did not permit this, enforced the order of line as formed, and instructed individuals not to run. Those of us identified as the first 27 were given business cards to identify our place, which we surrendered upon entering the courthouse. I was admitted that morning. On June 9th, I arrived at about 4:30 a.m. and found the line already extending down the sidewalk. I was the 31st person to arrive. A friend held a position ahead of me in line, offered to switch places with me, which placed me at number 27. That day, the court counted out the first 26 individuals. What? So they were from 27 to 26. However, I was admitted to the courtroom that morning and was present for the return of the verdict. During the times I was present in and around the courthouse, I did not observe any disturbance, security incident, or disruptive conduct by members of the public inside the courthouse that would explain excluding the public from the courtroom. The verbal altercations I witnessed occurred outside the building in the line prior to admission. Once admitted, those present in the gallery and waiting areas conducted themselves appropriately. On June 4th and 5th, I was excluded from the morning proceedings on both days. On each of those days, I was ultimately admitted in the early afternoon after a substantial portion of the day's proceedings had already taken place. The seats available to the public were few. The additional viewing location used during jury selection was discontinued once testimony began without prior notice, and my ability to observe the full proceedings on those days were curtailed as a result of the limited seating, the elimination of the overflow room, and the manner in which access was administered. On the days and portions of days on the days and portions of days I was admitted, I observed proceedings that were conducted in an orderly fashion, and I witnessed no conduct that would have justified restricting public access to the courtroom. All right, now we're gonna go back up to the judge's orders to the jury, and then we are gonna be done. We are gonna be done, y'all. I never thought I would hate reading. I mean, I don't hate it. I'm just tired. I don't want to read no more. Oh, I won't read a book for about 3 months, and I love reading. Oh my god. Okay, hold on. Go back, True. All right, so listen, y'all. And I don't know why this is like this. Like it's weird, but it look like they struggled to put these in here, baby. Oh, let me stretch. Oh, I'm gonna try to say, True, what the hell you doing? I'm stretching, damn it. Feel like I've been working out or some shit. Oh, okay. These are jury instructions, y'all. Keep you don't laugh at me, girl. This has been a day. My God. So, members of the jury, this is what Cockroach read to the jury before they were sent to the back to deliberate, right? Carmelo Sincere Anthony, the defendant, stands charged by indictment with the offense of murder, alleged to have been committed on or about April 2nd, 2025 in Collin County, Texas. To this charge, the defendant has pleaded not guilty. The law requires that I submit the following instructions to you in this case. These instructions contain all law necessary to enable you to reach a verdict. If any evidence was presented to raise an issue, the law on that issue must be provided. You are to read these instructions as a whole. The law applicable to this case is as follows: presumptions and burden of proof. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The law does not require the defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant, unless you are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in this case. The burden of proof in all criminal cases rests upon the state throughout the trial and never shifts to the defendant. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. If the state fails to meet its burden, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. Bodily injury means physical pain, illness, or any impairment of physical condition. Deadly weapon means anything that in the manner of is used or intended. Deadly weapon means anything that in the manner of its use or intended use is capable of causing death or serious bodily injury. Individual means a human being who is alive. Serious bodily injury means bodily injury that creates a substantial risk of death or that causes death. Serious permanent disfigurement or protracted loss or impairment of the function of any bodily member or organ. A person commits murder if he intentionally or knowingly causes the death of an individual. I'm going to read that again. A person commits murder if he intentionally or knowingly causes the death of an individual. A person also commits murder if he intends to cause serious bodily injury and commits an act clearly dangerous to human life that causes the death of an individual. A person commits manslaughter if he recklessly causes the death. So with this definition, if we had to give Carmelo a guilty plea, would y'all find him guilty of murder or manslaughter? Just from what we know, from everything we know about this case, including this motion that is filed. If you had to convict Carmelo of anything, would it have been murder or manslaughter? Let me know in the chat real fast. Let me know. Oh, okay. Interesting. Interesting. Neither. I would have convicted him of nothing. Okay. Natasha said neither. Queen said neither. Self defense. Okay. Okay. Mental state definitions as to murder. A person acts intentionally or with intent with respect to the results of his conduct when it is his conscious objective or desire to cause the result. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. I think you want to be somebody bitch. That's why you mad at him. Is that okay? Are you okay, John? I really believe, for those that come in here, you guys that supposed to be guys, that supposed to be men. I really think y'all, mad because you want to be somebody bitch and you can't. Or maybe you somebody bitch in real life and you're not a good enough bitch. I don't know. I mean, I just don't understand certain statements that you idiots come in here and put in my chat. Why are you concerned? A lot of y'all concerned about Carmelo's booty hole. Like, that's weird. That's really weird. But a bunch of you trolls are perverts. And y'all worrying about whether Carmelo is getting dicked down in prison. That's weird. Do you need to get dicked down in real life and you just can't? I'm not understanding the anger. I mean, I understand if you come in here and say Carmelo gonna spend the rest of his life in jail. Okay, that's your opinion. But for you to come in here and continuously talk about this man booty hole, like I'm looking at you like, damn, you mad? You angry? Upset? The fuck? Moving on. It's ridiculous. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. Murder. Now, bearing in mind the foregoing instructions, if you find from the evidence beyond a reasonable doubt that on that on or about April 2nd, 2025, in Collin County, Texas, the defendant Carmelo Sincere Anthony did intentionally or knowingly cause the death of an individual, namely Austin Metcalf, by stabbing off Austin Metcalf with a knife, a deadly weapon, or with intent to cause serious bodily injury to Austin Metcalf, an individual did commit an act clearly dangerous to human life by stabbing Austin Metcalf with a knife and a deadly weapon that caused the death of Austin Metcalf, then you will find the defendant committed murder as charged in the indictment. Let me read that again. Bearing in mind the foregoing instructions, if you find from the evidence beyond a reasonable doubt that on or about April 2nd, 2025, in Collin County, Texas, the defendant, Carmelo Sincere Anthony, did intentionally or knowingly cause the death of an individual, namely Austin Metcalf, by stabbing Austin Metcalf with a knife, a deadly weapon, or with intent to cause serious bodily injury to Austin Metcalf, an individual did commit an act clearly dangerous to human life by stabbing Austin Metcalf with a knife, a deadly weapon, that caused the death of Austin Metcalf, then you will find the defendant committed murder as charged in the indictment. If you do not so believe, or if you have a reasonable doubt thereof, you would next consider whether he committed the lesser included offense of manslaughter. Mental state definition as to manslaughter. A person acts recklessly or is reckless with respect to the result of his conduct when he is aware of but consciously disregards a substantial and unjustifiable risk that the result will occur. The risk must be of such a nature in degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person could exercise under all the circumstances as viewed from the actor's standpoint. Now, bearing in mind the foregoing instructions, if you find from the evidence beyond a reasonable doubt that on or about April 2nd, 2025, in Colley County, Texas, the defendant, Carmelo Sincere Anthony, did recklessly cause the death of an individual, namely Austin Metcalf, by stabbing Austin Metcalf with a knife, a deadly weapon, then you will find that the defendant committed manslaughter as included in the indictment. If you do not so believe, or if you have a reasonable doubt thereof, you will acquit the defendant and say by your verdict not guilty. If you find the defendant committed murder or manslaughter beyond a reasonable doubt, you will next consider whether he acted in self-defense. You are instructed that a person is justified in using force against another when and to the degree he reasonably believes the force is immediately necessary to protect himself against the other's use or attempted use of unlawful force. Hold on, y'all. All right, y'all. So you are instructed that a person who is justified in using force against another when and to the degree he reasonably believes the force is immediately necessary to protect himself if against the other's use or attempted use of unlawful force. The use of force against another is not justified in response to verbal provocation. See, this is what fucked them up right here. Uh-huh. The use of force against another is not justified in response to verbal provocation alone, or if the actor provoked the other's use or attempted use of unlawful force, unless the actor abandons the encounter or clearly communicates to the other his intent to do so reasonably, believing he cannot safely abandon the encounter. The other nevertheless continues or attempts to use unlawful force against the actor. A person is justified in using deadly force against another if the person would be justified in using force against the other, and when, to the degree the person reasonably believes the deadly force is immediately necessary to protect himself against the other's use or attempted use of unlawful deadly force. A person who has a right to be present at the location where the deadly force is used, who has not provoked, this is where he fucked up. He telling the people, being as though Carmelo was there and shouldn't have been there, and that he provoked Austin, he cannot use self-defense. This is what he fucked up at right here. A person has a right to be present at the location where the deadly force is used and has not provoked the person against whom the deadly force is used and who is not engaged in criminal activity at the time, and deadly force is used, is not required to retreat before using deadly force. And the factor of fact, when determining whether the actor reasonably believed that the use of deadly force was necessary, may not consider whether the actor failed to retreat. Where there is more than one assailant, the defendant has the right to act upon the hostile demonstration of either one or all of them and to assault either one. Wow. This is, if reasonable appears to him that they are present for the purpose and together to take his life or to do him serious bodily injury. Reasonable belief means a belief that will be held by an ordinary and prudent person in the same circumstances as the defendant. Deadly force means force that is intended or known by the person using it to cause, or in the manner of its use or intended use, is capable of causing death or serious bodily harm. You are further instructed that if the duty to consider all relevant facts and circumstances surrounding the alleged killing and the previous relationship existing between the accused and the deceased, if any, together with all relevant facts and circumstances going to show the condition of the mind of the accused at the time of the alleged offense. Now, therefore, bearing in mind the foregoing definitions and instructions, if you believe from the evidence beyond a reasonable doubt that the defendant in Collin County, Texas, or on or about April 2nd, 2025, did commit murder or manslaughter, but you further find from the evidence or have a reasonable doubt thereof that the defendant reasonably believed that deadly force, when and to the degree used, if it was immediately necessary to protect himself against the use or attempted use of unlawful deadly force by Austin Metcalf or others with him, you will acquit the defendant and say by your own verdict not guilty. You are further instructed, however, that if you believe from the evidence beyond a reasonable doubt that at the time and place in question, Austin Metcalf or others with him were not using or attempting to use unlawful deadly force on the defendant, or that the defendant did not reasonably believe that his use of deadly force was immediately necessary, then you will find against the defendant on his plea of self-defense. Yeah, he made sure he worded this right. And then right in his eyes, right? And in deciding whether the state has proved that this defendant did not reasonably believe his use of deadly force was necessary, you must not consider any failure of the defendant to retreat that may be shown by the evidence if you find both. The defendant did not provoke Austin Metcalf, the person against whom the defendant used deadly force, and the defendant was not engaged in criminal activity at the time he used deadly force. If you do not find both 1 and 2, you may consider any failure of the defendant to retreat that might be shown by such and such in deciding whether the defendant reasonably believes that the use of deadly force was necessary. If you find and believe from the evidence beyond a reasonable doubt that the defendant immediately before the difficulty did some act, used some language, or both, see, this is him pretty much telling the jury, if you think that Carmelo provoked Austin, find him guilty. In a nutshell. Because see, you got to remember from day one, they put it out here that Carmelo provoked Austin, which is a lie. Right? So even in his instructions, he is telling the jury, if you think, now these are people who already feel like Carmelo provoked Austin, if you ask me. So this is the judge telling them, if you feel like Carmelo provoked Austin, he's guilty. Pretty much. Wow. If you find and believe from the evidence beyond a reasonable doubt that the defendant immediately before the difficulty did some act, used some language, or both with the intent. That's why they told that lie talk about, he said, that's why them lying students got up on that stand and told that lie talking about Carmelo said, push me again and see what happens. Yeah. Or use some language or both with the intent to produce the occasion to bring on the difficulty and kill Austin Metcalf, and that such conduct was reasonably calculated to and did provoke a difficulty, which is a fight, and that in response to this provocation, Austin Metcalf attacked the defendant or reasonably appeared to attack him, or reasonably to appear. He did attack him. He pushed him. Ooh. Or to be about to attack him, and that the defendant then killed Austin Metcalf in pursuance of his original design. If you find there was such or produced a necessity for taking the life of Austin Metcalf, you will find against the defendant's claim of self-defense. Wow. At times throughout the trial, the court has been called upon to pass on the question of whether or not certain offered evidence might properly be admitted. You are not to be concerned with the reasons for such rulings or and are not to draw any inferences from them. Whether offered evidence is admissible is purely a question of law. In admitting evidence to which an objection is made, the court neither determines what weight should be given such evidence nor passes on the credibility of the witness. As to any offer of evidence that has been rejected by the court, you, of course, must not consider the same. As to any question to which an objection was sustained, you must not conjecture as to what the answer might have been or as the reason for the objection. The fact that the defendant has been arrested, confined, or indicted for or otherwise charged with the offense gives rise to no inference or guilt at his trial. You are instructed that you may consider all relevant facts and circumstances surrounding the killing and the previous relationship existing between the accused and the deceased, if any, together with all the relevant facts and circumstances going to show the condition of the mind of the accused at the time of the offense alleged to the indictment. You are instructed that the defendant may testify in his own behalf if he chooses not to, but if he chooses to do so, but if he elects not to do so, that fact cannot be taken by you. Um, you are instructed that you may consider all relevant facts and circumstances surrounding the killing and the previous relationship existing between the accused and the deceased, if any, together with all relevant facts and circumstances going to show the condition of the mind of the accused at the time of the offense alleged in the indictment. You are instructed that the defendant may testify in his own behalf if he chooses to do so. But if he elects not to do so, that fact cannot be taken by you as a circumstance against him or prejudice him in any way. The defendant has elected not to testify, and you are instructed that you cannot and must not refer to or allude. Why is those words throughout your deliberations or take it into consideration for any such and such whatsoever? I hate that they messed up those words, but okay. Um, Concluding instructions. You are charged that it is only from the witness stand that the jury is permitted to receive evidence regarding the case, and no juror is permitted to communicate to any other juror anything he may have heard regarding the case from any source other than the witness stand. In deliberating on this case, you are not to refer to or discuss any matter or issue not in evidence before you. Further, you shall not talk about this case to anyone not of your jury. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given to the testimony, but you are bound to receive and to follow the law from the court. After you have retired to consider your verdict, no one has any authority to communicate with you except the bailiff who has you in their charge. You may communicate with this court in writing, signed by your foreperson through the bailiff who has you in their charge. Do not attempt to talk to the bailiff, the attorneys, or the court concerning any question you may have. After argument of counsel, you will retire and select one of your members as your foreperson. It is the duty of your foreperson to preside at your deliberations and to vote with you in arriving at a verdict. Your verdict must be unanimous, which means everyone should vote the same way. And after you have arrived at your verdict, you may use one of the forms attached by having your foreperson sign that particular form that conforms to your verdict. And then he signs it, and This is the verdict sheet. We, the jury, find the defendant guilty of murder as charged, or we, the jury, find the defendant guilty of manslaughter, or we, the jury, find the defendant not guilty. And we know what they found, right? Right. All right, y'all. That's gonna be it on that. So what we waiting to see is we waiting to see if uh well, I did tell y'all that there's a form out there. I don't know if it's real or not, so I'm gonna go try to find it myself. There's a form out there that stated that Judge Roach declined to recuse himself, but I got to see how true that is on my own, and then we're also waiting to see if they're gonna because let me be clear. Let me be clear one more time before we end this. This motion, right, is not a motion for the actual retrial. This motion is to ask that the judge recuses himself or is recused from any further hearings pertaining to Carmelo Anthony or the state of Texas versus Carmelo Anthony. Any proceedings, anything. And is also asking for an evidentiary hearing to determine if Carmelo Anthony should receive a new trial. So, we'll be waiting to see what happened, and we'll be coming with the updates. With that being said, y'all, that's it. I will see y'all tomorrow morning at 9 o'clock a.m. sharp. I appreciate the support. I appreciate y'all supporting this channel, these long as live streams. Shout out to my moderators. Shout out to my new subscribers. If you're in here or catching a replay and you like the content, please make sure you like the live and also subscribe to the channel. All right. We're going to call it a day for the day. I'll see y'all in the morning. Thank y'all so much for supporting this live. All right. Shout out to y'all. I'll see y'all on the other side. All right. Until then, y'all be safe, be blessed, never stressed. And until next time, truth seekers stand up and we out. Y'all be good.